Miscellaneous intangible plant of $27.8 million has accumulated depreciation of $21.7 million against it, with $6.1 million left to be depreciated. It consists of assets including interactive voice replacement, mapping software, and the Active Directory.
I'm sorry, that was read in I, is that correct?
Yes.
Read it, thank you.
Ms. Van Lulling, could you also please provide read in J?
Yes. These are Gen Con incomes related to technical service. There is no allocation or base expenses of technical services related to Gen Con. Therefore, the incomes are not included in the base calculation.
Thank you. And lastly, for Ms. Van Lulling, read in O.
OCC 300 SCG Attachment 1 reflects an increase in Board of Director fees from 2021 to 2022. The primary driver of this increase was the addition of a board member to the Avangrid Networks Board. This board member is a female, increasing board diversity. She has more than 37 years of management and senior leadership experience in the financial industry with expertise across core disciplines, including operations, risk management, sales management, and client experience. Her experience in these areas, particularly her expertise in customer service, allows her to provide guidance and feedback to the company to the benefit of customers. The $7,000 legal fees on row 30 are related to fees paid to White & Case to provide legal support on SEC matters, as well as the annual meeting of shareholders. These are not new fees in 2022. However, prior to 2022, they were not charged to the SEC legal fee order, which is what is represented in the schedule. They were charged to general legal services. The amount charged to SCG in 2021 was consistent with 2022 of $7,000, and those similar charges were charged prior to 2021 since we've been a public company. The allocation factor used for investor relations is the Massachusetts formula, and the Avangrid Networks Board meets 5 times a year.
Thank you, Ms. Van Lulling. Ms. Wakefield.
No.
Okay. We'll need a little more time on read-ins M, L, and N.
Okay, thank you. Anything further?
Yes.
Okay, very good. Then we will resume cross-examination of the revenue requirements panel by the OCC, please.
Sorry, Chairman, I actually do also have an administrative matter.
Oh, I apologize. I didn't ask.
No problem. That's not a fun one, unfortunately. I was late getting to the hearing room yesterday. I walked in immediately after the authority's announcement about the scheduling change. And I think the chairman asked the OCC's position on it. And we didn't, since I wasn't in the room at the time, we neglected to report to the authority that Dr. Woolridge can't be here on Monday. We don't have an objection to Ms. Bulkley or the EOE's witness going forward on Monday in Dr. Woolridge's absence, but Dr. Woolridge just can't be available to be here himself to testify on Monday. And the other, perhaps the other worse update I have is that I had communicated to the authority earlier, I think on the first day, that our capital investment panel is generally available next week. I got an update this morning that Dr. Hopkins can't be here after noon on Wednesday, but can be here on every other day of the week. It's just that he has to get back to Massachusetts for Wednesday afternoon.
Okay. Okay. I'm sorry, Dr. Woolridge can be here Tuesday,
Yes, and Wednesday.
Tuesday and Wednesday. And Ms. Bulkley can be here Monday and Tuesday.
That's right. Yes, the 29th and 30th.
Okay. All right. Well, we'll have to do some juggling. I understand. All right. Let's go forward with Cross, please.
Thank you, Chairman. We're going to start with just, I think, 2 follow-up questions from me before proceeding with Mr. Sobolewski. Yesterday, I asked this panel a question about retention bonuses, and the panel asked for a reference. And I ultimately ended up not providing a reference, but asking some questions about the ratification bonus. Excuse me. And I requested information about any ratification bonuses paid between 2018 and 2021. Do you recall that line of questioning?
I do. I think we have an open read-in on that matter.
Yes. Thank you. So my hesitation yesterday about citing a reference was for 2 reasons. The reference that I have is a CNG sponsored interrogatory response, which is RRU 144. And a portion of that response was answered confidentially. So I needed to make sure that my question wasn't verging into the confidential area of that response, but I don't think it is. I also suspect, though, since that response was sponsored by the Compensation and Benefits panel, that I'm going to be referred to that panel anyway. But my question, what I would like is the same information that I requested about the ratification bonus as to the retention bonuses as referenced in that response.
Just one moment.
Sure.
Just to make sure I understand what you're seeking. RRU 144 CNG attachment 1 redacted on the tab pivot summary indicates that there was a $20,000 retention bonus, and this is the redacted version that I'm reading from, so I don't think that's confidential. You're asking for the comparable value for SCG?
I'm asking, yes, but also for the values going back from the comparable values for both companies going back to 2018.
I understand. I think that would have to be provided by the Compensation and Benefits panel, but I'm sure it's possible.
Okay, thank you. I'll just ask for it again. And my last question, just a follow-up from some questions from Mr. Paff's questioning yesterday, which led to the request for late file 43, which is according to my notes, is a reconciliation of the plant model to the periodic plant updates that have come in and will continue to come in through that date. Just for clarification, would that consist of sort of an accounting exercise of moving the numbers from forecasted into actual plant, or is that going to have an ultimate effect on the revenue requirement that's different from the current plant model? Or does the company not yet know until that exercise is completed?
So I think the preparation of that particular late file will not affect the revenue requirement because we're simply going to prepare a reconciliation. However, LFE1, we do intend to update the revenue requirement to reflect actual plant additions through the most recent date available, which could affect the revenue requirement.
Okay. And that, with the impact of the revenue requirement, you know what, I'll ask, we'll see what's in late file 1 and I'll ask during the late file hearing.
I think that's the right
Thank you.
call. Thank you.
And with that, I'll turn it over to Mr. Sobolewski. Thank you.
Good afternoon. Good afternoon. Thank you. Richard Sobolewski, Supervisor of Utility Financial Analysis for the Office of Consumer Counsel. If we could turn to Schedule B-6.0. My questions are going to be similar to what I asked the other day. Some are a little different. Looking at SCG's Schedule B.60, there's a $15.628 million for the test year for the pension regulatory asset. And then there's an interim rate year interim period adjustment of 16.5 million to get to 32.16 million. And then there's, for the rate year, there's a downward adjustment of approximately 5.5 million to get to about 26.7 million. If I wanted to speak to someone about the cause of the decreases, I should speak to the pension panel.
One moment. Maybe you give it a try right now and we'll
Okay.
give it a whirl. We can speak to some elements of this and then there are others for which we
Sure.
would need to collaborate with the comp and benefits panel.
Okay. What's the exact reason for the pretty large increase in from the test year to what's in the interim year and then the rate year?
Everything that we've reflected in the revenue requirement was derived from actuarial reports provided by the comp and benefits panel. This is simply the mathematical flow through of those actuarial projections, which were provided in exhibits SCG CBP 11. And subject to check, I believe it came from page 17 of that
Okay.
attachment.
And the methodology used for SCG was the same as what you utilized for CNG, is that correct?
It was.
Looking at OCC 255, attachment 1. The interim year and rate year, those are calculated using projections, is that correct?
That's correct. The interim year and rate year values reflected in OCC 255 SCG attachment 1 were derived from the calendar year values presented just to the left, which are from the actuarial report I just referenced.
These are projections, they're not prepayments, correct?
These are projections. However, we have funded the plan. There is a fair value asset of the plan that's included in there. There are projections on that fair value of the asset, what will happen to it, but there is an underlying actual asset that has been funded.
Well, in regards to a prepayment where the company or its shareholders paid more than what the pension expense was for actuarial purposes or what was done for rate making purposes, that doesn't really figure into the calculation, does it?
You're talking historical, where are we from a historical perspective?
Right.
The historical perspective would be in 2023 or in the 2022 actuals.
But that balance that's here, that's in rate base, is not designed to be, well, Pura allowed us $5 million of pension, we put in 6 million, so that balance keeps increasing by a million. That's not what that's designed to be.
So what we're shown here in B6, we take the projected benefit obligation that we have, that is based on actuarial assumptions. We subtract out the fair value of the assets, again, based on actuarial assumptions, assuming to inflate at that point in time. And then we take out of it the actuarial losses which are theoretically the losses that have not yet been recognized. So the theoretical losses, and that is what's shown in B6.0.
When you say they haven't been recognized, they haven't been amortized in the pension calculation?
Correct. They have not been amortized into the income statement as of yet, but they're the balances that sit within the projected benefit obligation.
And is that same for the unrecognized gains as well?
That, yes, but right now, one moment. Right now, we're in, the net position is losses.
Okay, the other day, there was a discussion about the OPEB balance that's in Schedule B dash 8.0.
We're here.
Okay. Is that's similar in nature to this pension item, right?
The calculation is done with the same methodology that I just described. It's just going the other way.
So it's in that schedule because it's an offset to rate base?
When I take the projected benefit obligation, subtract the fair value of the assets, and then back out the net actuarial losses, I am now in an overfunded position, and that's why it's a reduction to rate base.
But the same thing, it's based on projections, the actuarial assumptions.
It's based on the projections for the test year, correct? And the actuarial assumptions, again, are baselined in some actual items that have occurred, such as the fair value of pensions, fair value of assets. That is the underlying basis for the actual assets assumption that we have.
In your response to RRU 457, you gave an example for CNG of how the balance was included in what was approved in the last proceeding in the settlement. Is that correct?
RRU 457 was a response related to CNG, but conceptually, what you described is correct. I don't recall if there was an SCG peer to this question, but
SCG's last case was also settled, is that correct?
it was.
Similar type of deal, three-year, multi-year rate case?
It was.
If there was a balance allowed for pension regulatory asset, similar to what we discussed the other day for CNG, if it was allowed, you would have allowed to earn a rate of return on that amount.
The concepts for CNG and SCG here would be the same.
The balance is different by what was in the case, but if it was allowed, then it would also be at the allowed overall rate of return.
We would have applied the allowed overall rate of return to rate base. That's correct.
In regards to past treatment for SCG, is there anything that you'd like to add? Were there specific cases that items were specifically allowed, or there was a decision from Pura that said that's the correct methodology?
Did we take a CNG late file on this?
I don't recall whether there's a late file, but the same question was asked of the CNG panel.
It would be a similar answer. I'm not aware of a distinction between CNG and SCG on this item.
Okay. All right, if we could move on to, on the same schedule, B-6. There's a non-firm margin. My understanding is at the end of the test year, there was a balance of $13.335 million as a regulatory liability. Is that correct?
Mr. Sobolewski, you're referencing Schedule SCG B 6.0, line 21.
Yes.
You said 13.335 million?
Yes.
Yes, I see that.
Okay. Now, my understanding is that's comprised of a couple different pools of non-firm margin. Is that correct?
That's my understanding as well.
We have items that were deferred in the proceeding that ended the system expansion plan. And then there's other non-firm margin that was diverted, set aside for the system expansion plan that maybe my classification isn't, the way you'd say it, but it's like items that weren't already used by the company to support the to support expansion projects.
I might just restate that in my own words. My understanding is there is total non-firm margin, which is comprised of 3 buckets: customer non-firm margin, project non-firm margin, and surplus non-firm margin. My understanding is customer non-firm margin for the past several years has been already goes back through the purchase gas adjustment clause. Project NFM is the NFM that could have been used during the system expansion plan to buy down customer kayak requirements. And then surplus NFM is anything that's left over after customer and project NFM. This bucket, as I understand it, includes both project and surplus NFM.
Okay.
And I think we've provided a more official definition of those from some authority orders on the record somewhere, but I think that's directionally accurate.
The way the non-firm margin is accounted for is 50% of it goes back through the PGA, 50% is set aside, was for the system expansion, and now it's going into as a rate base, in the rate base, right? Deferred and rate base.
I think conceptually that's pretty close. My understanding is customer NFM is 50%, and that's the portion that has and will continue to go back through the PGA. My understanding is there is a cap on the total amount of project NFM between CNG, SCG, and Yankee Gas. And then anything left over is surplus NFM, given that 50% is customer. By definition, the total of project and surplus should be the other 50%. But I understand that these different categories have a well-traveled history in Connecticut, so I'm just trying to be clear on the differences.
And the cap's $15 million between the 3 LDCs?
That sounds correct.
Okay. Historically for SCG, since system expansion started, it's been in the range of $4 to $5 million a year. Is that in the ballpark?
Project NFM?
Well, the customer piece is $4 to $5 million, and I guess project is $4 to $5 million.
My understanding is project NFM has been in that range. I don't have the historical numbers at my fingertips, but we may have someone in the audience who could help dig that up if that would be helpful.
No, I mean, that's fine. Now, the question of what's currently a rate-based credit. I think at this point, would you agree that the balance has grown since the test year, so it's something above $15 million?
I would agree the balance has grown. I don't have the current balance, so I don't know if it's in excess of 15, but conceptually, I agree it will be growing.
Okay,
I'm being told it is in excess of 15.
okay. Let's just assume it's $15 million for
All right,
this discussion, okay?
done.
So if the $15 million is returned to ratepayers through the PGA, those ratepayers would see a $15 million reduction in their purchase gas costs.
They would.
Now, through the rate base credit, in a rate case, you don't get the credit until there's a rate decision, and that gets included in the calculation of the revenue requirement. Is that correct?
From a ratepayer's perspective, that's correct. We would include the amount in our computation of rate base on a regular basis in the RWE filings that we make, but as it's certainly been discussed on the record, the company's base distribution rates would not change absent a rate case.
So going forward, if the next rate case isn't for 3 years and in between rate cases, there's no additional credit flowing back to ratepayers unless some new methodology was created. Is that correct?
Yeah, I certainly wouldn't be aware of how that would happen absent a new methodology.
Okay, and that $15 million credit hypothetically.
Might just add, Mr. Sobolewski, that this is also a one-year case.
Right. The $15 million credit, what ratepayers receive back is the offset to rate base, the value of that. So I think the company's requested ROR is a little bit above 7.5%.
That's correct.
So at 7.5%, I calculate the credit as a reduction to revenue requirements of $1.13 million.
I got.
I didn't gross that up or anything for taxes, but
You read my mind. I got the same math, but that would then be grossed up for income and income tax, gross earnings tax on collectible. But it will still certainly be far short of $15 million.
and that gross up's like like the revenue conversion factor is like 1.386 or something.
I can get the specific number. I have 1.4571.
Okay, so it's something in the neighborhood of 1.5, $1.6 million.
That sounds directionally accurate.
Okay, and in regards to non-for margin, you see that continuing
In other words,
going forward.
that credit's not going to go from something in the range of 1.5 to 1.6 million to 15 million.
No, I mean the total rate, your total non-for margin proceeds that you generate every year. It's been $8 to $10 million for, a decade or more. Does the company project that that's what's going to continue?
Let me confer with an SMA really briefly. The company will certainly be continuing the activities that give rise to non-firm margin. We haven't prepared a forecast of what that will be, but absent anything further, history is a guide, but we have not made an official projection as to what that is.
And as long as the environment stays the same, and what you're required to purchase as gas supply, you'll continue to have supply that you can sell off as interruptible or non-firm. Is that correct?
We would certainly look to continue doing that. And I think something in your question, I'll just emphasize, it's those supply-related activities that give rise to our ability to earn non-firm margin. And that's one of the reasons why we thought it was important to return this credit to customers through the PGA, because it better comports with the principle of cost causation. Those are the customers who are paying for the underlying activities that enable us to earn this. And so we think they're the customers who deserve the credit.
And part of the reason is that you have this capacity to sell is your supplier of last resort responsibility. Is that correct?
One moment. That's correct. And the company's response to Pura 46 describes in further detail the activities that give rise to NFM.
I have a couple other questions on the other amortizations in WPC 3.23.
What?
2.3, I think. We are there.
In this rate case, there's a large balance there because of the agents. Is that correct?
When you say large balance there, you're referring to the line labeled tax reform post remeasurement deferral.
Yes.
I want to agree with you, but since we have our tax panel sitting in the audience,
Okay.
I want to be just very precise about the language. These are not technically accumulated deferred income taxes. Rather, these are current income taxes, which the company has deferred.
Okay. But this is a large amount.
It is tied to tax reform.
Okay. And I know the last rate proceeding, there was also a large balance, not tax related, but it was a deferred, like the hardship forgiveness or hardship, the difference in hardship on collectibles. Does that sound familiar?
It does. I don't recall with certainty whether that was reflected in the last case, but I can check very quickly. It was.
Okay, so, I mean, this amount seems what's in this case right now seems much larger amount, and there's a big pool of items going through this schedule. Would you agree to that?
I would agree that the tax reform post remeasurement deferral is far and away SCG's largest regulatory liability being proposed for amortization in this case.
Question is, why for simplicity reasons wouldn't it just be to use the same amortization period for everything in the schedule?
And we grappled with just that. Ultimately, we chose to propose a 10-year amortization period for this particular regulatory liability for a couple of reasons. First, we thought about this from the customer's perspective. A shorter amortization period would result in more money going back to customers in the short term, but it would result in a very dramatic rate cliff as soon as that amortization ends. And while any amortization will technically have a rate cliff at the end, we judgmentally felt that a 10-year amortization would best allow us to return money to customers in a timely fashion without having that significant cliff at the end of the amortization period. Second, we were cognizant of the effect of this amortization on the company's cash flows. While we did not specifically study the effect of this particular amortization on the company's cash flows on a standalone basis, we did submit a data request response, which was sponsored by our cost of capital panel, providing some analysis of the effect of the OCC's revenue requirement recommendations overall. And I think the cost of capital panel could speak to that calculation further.
Okay. By a rate cliff, basically you're saying you have this revenue requirement offset in your calculation. And then when that amortization is complete, you're basically driving a rate increase. Is that correct?
That's exactly correct. And this, I think, further distinguishes the tax reform post-remeasurement deferral from NFM, because the tax reform post-remeasurement deferral, once rates in this docket take effect, will be done. That's not going to continue accruing. However, as you noted earlier, non-firm margin is likely to continue into the future.
Mr. Spilewski, one thing I would add, and we know this in our rebuttal testimony, is that the company plans to return the entirety of that regulatory liabilities to customers, and until that happens, to continue to accrue carrying costs on the liability consistent with the approach used on regulatory assets.
Okay, so the portion not returned is an offset to rate base.
That's correct.
And you can see that on Schedule B 7.0.
I have a clarifying question, and from the cross that's happened earlier in this proceeding on carrying costs versus non-carrying costs, and what items get carrying costs and not. Let me see if you'd agree with this characterization. For most of the regulatory assets, until they go into rate base in a rate case, you're calculating carrying charges on those?
For regulatory assets that had a corresponding cash expenditure. And the distinction I'm trying to draw there is between a regulatory asset that we would put on our regulatory amortization schedule as compared to a regulatory asset for GAAP purposes.
Okay, and the same for regulatory liabilities?
Correct.
And just to add to that response, as Mr. Hurwitz said, it's the instances where cash has been outlaid. And so said another way, that's where the company has committed capital to support that deferral. Or vice versa, customers have paid for the regulatory liability. For the costs underlying regulatory liability.
And for some of these, you may have been specifically directed by PURA in a decision or ruling of some type that established the regulatory asset or liability. Is that?
I am aware of certain PURA orders commenting on the appropriateness of carrying costs. The only ones that are top of mind are for the company's affiliate, the United Illuminating Company. There may have been some for SCG as well, but.
Okay. On the tax liability, that.
One moment. The EDF regulatory asset, that order does contain language on having carrying charges on it.
Do you know if the tax liability did?
I think our settlement agreement did.
Okay.
Yeah.
Follow up on that. Do you know if there was a PURA order subsequent to the settlement agreement that clarified the carrying cost treatment for that tax liability?
There may have been.
Okay.
Thank you. That's all I have.
Thank you.
And that's all the OCC has. Thank you.
Thank you. EOE, please.
Good afternoon. Good afternoon, Kim White, EOE. So before we get started here, Mr. Parent is going to ask you some specific questions regarding SCG. But before we start that, I was going to pose a question to Mr. Venora, if I may. The other day, Tuesday, I believe it was, Mr. Parent asked several questions to the CNG panel that were generally applied to both companies. They weren't questions relative to CNG specific filings. They were kind of procedural, conceptual questions that applied to both companies regarding regulatory assets, liabilities, insurance, mutual aid, and the customer perception studies. In lieu of us reiterating each of those questions and us spending a couple hours doing that, would you be willing to stipulate for this portion, for the SCG portion of the proceeding, that you answer all of Mr. Parent's generalized questions exactly the same as the CNG panel did the other day, and that maybe we may rely on those answers for the SCG panel here?
Yes, we would, with one caveat. I think on the topic of pensions, I think there might be some nuances between the companies where we'd ask those questions to be re-asked, but otherwise, yes, we can agree to that stipulation.
Certainly. And then the same would apply to the questions that Attorney Wyman and I asked of Ms. Michelson. Those were generalized questions applying to both companies. Would you equally stipulate that we are asking those questions again and that you stipulate to the answers that you provided for the CNG panel for those questions?
Yes.
Very well, then Mr. Parent will proceed with the questions specific to the SCG.
Thank you. Good afternoon, panel. Chris Parent from EOE. That stipulation, I think, might save a few minutes. I'm going to start. Many of my questions are going to be very specific and actually tie out some very specific numbers. I'm going to start to refer to EOE 403 attachment 1.
I'm there.
Okay, so I was trying to reconcile the company's response between this response and what was provided in EOE 479. However, it appears that page 3 of this response is a PDF that references page 1 of 2, and there's no visual for page 2. So it's basically like an embedded picture. Can the company supplement its response, or I might need a late file to actually obtain the missing information?
Most likely. I just want to make sure I understand what you're seeking because I don't yet see the missing page you're describing. You just
So-
run me through the references again.
Sure. So at the top of page 3, you're going to see an exhibit for
I'm sorry,
Connecticut.
Mr. Parent. Page 3 of which?
Oh, apologies. So EOE 403 and it's attachment 1.
Okay, I'm there.
So the top of what's referred to as page 3, you have Connecticut Natural Gas, and it's a single picture. At the bottom of that page, it's references page 1 of 1.
I see.
You'll look at the picture below it, it says SCG, and it's references page 1 of 2.
I gotcha. We can absolutely check if there is a page 2 of 2, and if there is, we can provide it.
That'd be great.
Since it may be a mistake in the filing, it could just be refiled if necessary. I'm not going to mark that a late file.
Sure, we could do that as a supplemental or revised to the discovery response.
Thank you.
Okay.
You mind if I take just one moment to confer and
Absolutely.
we will research and supplement if necessary.
Thank you. I will say that I was footing numbers and it wasn't footing. I figured it out finally when I saw that, so
It very well could be the case. Apologies.
no worries. Staying with the same attachment, am I correct to understand that some of the accident dates relate back to either 2013 for PMA, which is pages 1 and 3 of the filing, and even 2009 for Liberty Mutual, which is pages 2 and 4?
I do see dates from 2013 on certainly page 3. And I see them also on page 1. For Liberty Mutual, I do see dates in 2009 certainly on page 4 and also on page 2.
So essentially, to paraphrase, what that means is that we have some reserves that would be in excess of 10 years old. Some claim activity that has a reserve associated with it.
I would agree.
Referring to OCC 532 attachment 2, as well as the revised C316. So it's C316, which is from OCC 532 attachment 1. So it's basically OCC 532 attachment 1 and 2. Acknowledging that 1 is an update of C316. Sorry if that's confusing. It confused me.
And I assume you're referencing the revised attachment 1.
Correct.
I have both of those open.
So am I correct when I look at page 1 of 3 of attachment 2 that the difference between the Q4 of 21 and in this case, what is the 3Q of 22 is the basis for the $82,000? So I'm basically confirming a footing exercise.
I agree that the $82,000 income statement activity reflected on OCC 532 SCG attachment 2 is calculated by comparing the 2022 balance to the 2021 balance, both shown directly above.
So now shifting over to attachment 1, that 82,000 appears to be reflected on the workers' compensation exhibit, which is page 7 of 9. Oddly enough, this one doesn't reference which it's C316, but it doesn't reference, I think it's E if I'm not mistaken.
I agree based off of the tab name.
Yes.
And I see the same 82,000.
Okay. So for SCG in the current scenario, am I also correct to observe that the 82,000 is actually resulting in an increase to the workers' comp expense? Different from our discussion on CNG on Tuesday, where CNG's amount was resulting in a decrease.
One moment. I agree that the SCG adjustment is an upward one, whereas the CNG adjustment was a downward one.
Thank you for the correlation. One of the late file requests from Tuesday, which was LFE 24, was to obtain exhibits from the prior rate case indicating if the reserve, the IBNR specifically as you refer to it, was removed. Has the company looked into this yet? And is the company aware of the response for SCG?
No and no.
Chair, I'd like to request a comparable late file to late file 24.
That is now late file exhibit 51.
So this is kind of a generalized question here. So given that the reserve balances that we saw in the corresponding activity could be related to accounts or claims that are over 10 years old, why did the company decide to exclude the current period's change, which for SCG is a increase? So essentially by removing, I'll editorialize if I can, by removing the current period, in this case, it would be the prior year of 21 through the third quarter of 22 by removing the change in IBNR, the change in the reserves in that period. And we're not sure if there was a similar treatment in the prior rate case, but by only removing that small period, when these relate to claims that could be in excess of 10 years old, what's the logic behind that?
While we have removed these income statement effects of IBNR reserve changes via pro forma, just like UI did in docket number 220808, we have included the underlying claims expense in our proposed revenue requirement.
Well, so in this case, the overall amount included the 82 and then included the 82 as a reduction, and now it's adding it back in. So it's so the original claims expense would have had a reduction of 82,000, and now this pro forma adjustment here is increasing it by 82,000.
I might say broadly, and as we've described in a data request response, workers' compensation, the amount of workers' compensation expense recorded by the company in the historical test year included 4 components: premiums, claims, IBNR, and disability. We chose to pro forma out IBNR activity, which was a more than $400,000 adjustment downward at CNG. And you're right, it was an $82,000 upward adjustment at SCG. But we felt it most appropriate to seek recovery of our claims expense, realized claims expenses, in lieu of reflecting these IBNR reserve adjustments in our proposed revenue requirement.
So I guess I'm trying to understand why, though. If you think about the 2022 expense, at present, the first column for the test year included the change. So the change in the IBNR plus I'll refer to as any paid activity. So the combination of those two reflects your expense, and I'm generalizing. I do understand the professional insurance expense and whatnot. But by backing out the change in IBNR, it's backing out a change in reserve, and I'm not appreciating the why. And I did just hear your response, but it wasn't clear as to the why. A pro forma adjustment, if you chose to not recover something, okay, I understand that. In this case, it's additive.
We added these pro forma adjustments to the revenue requirement in part to follow in the footsteps of what UI did and what the authority ultimately approved in docket 220808. If the preference is to not make these pro forma adjustments, we would be amenable.
Okay. I'm going to move on. But the next item was, I would like to request a similar late file to that of CNG's late file 26.
I'm sorry, it's the same one as which one?
Late file 26. Listing of all reserves.
Yeah. Thank you. So that's late file exhibit 52 for SCG.
Thank you. On Tuesday, I had asked some foundational questions with regards to medical and disability, and the panel deferred me to the company's compensation panel. Still appropriate? Okay, I'll save that for that panel. Thank you. Next up, I'm going to move on to is pension. Similar to Tuesday's question to SCG, am I correct to understand that the pension regulatory asset is for projected amounts that have not yet been funded by the company? And this would be referred to on the transcript on page 396, give or take, depending.
The regulatory asset, are you referring to the one that we're asking for in B 60.0?
Yes.
Okay. That regulatory asset is calculated using the projected benefit obligation, less the fair value of the assets, less the actuarial losses. And so to your question on, is it calculated using future assumptions? There are future assumptions. However, the underlying basis of some of the assumptions, like the fair value of assets, is an actual known fair value as of a certain point in time, projected on what that future value will look like.
So the question that I had posed on Tuesday was, is it pre-funded? And on page 396, I believe the answer was it's not pre-funded. Is that the answer for SCG as well?
Can you define pre-funded for me?
So the broad discussion that we had on Tuesday with regards to regulatory assets and liabilities would be that a regulatory asset would exist if the company had expended capital or cash of some sort. Other situations could present, Mr. Hurwitz explained. In this case, for this line item, my question, and it sounds like OCC was also just asking, I'm trying to understand if this is actual capital that has been expended already that would warrant it being treated as a regulatory asset. So if it has been pre-funded or if it will have been pre-funded before the rate case or the revenue requirements would commence.
Thank you. That's helpful. So what we've included here is our best effort to get to the funded amount, the amount that is funded by taking that projected benefit obligation minus the fair value of the assets, less the actuarial gains and losses. So in our position of taking out the actuarial gains and losses, that are the actuarial gains and losses that have not yet been recognized. And so that gets you back to a position that's either funded or unfunded.
But has the company actually paid out capital to establish this regulatory asset? Has capital gone out the door?
The capital has gone out the door to establish the the assets within the pension plan.
Okay, so tying that off with the actuarial assumptions and everything that's in place, when we look at the pension benefit obligation and the fair market value, has the company put forth more than was necessary to derive the pension benefit obligation itself? So has the company paid more than the minimum obligation that would warrant the inclusion as a regulatory asset?
Is your question, have we paid more than the minimum obligation?
Well, so when I think of ERISA standards, the company is required to fund 80%.
Mhm.
Would you agree with that? In this case, I would have imagined that a regulatory asset could be established if the company had funded an amount in excess of 100%. Because the company is only required to fund the 80%. Please correct me if you feel as though I'm saying anything wrong. So if has the company funded 100% or more than 100%?
That question is better posed for the Benefits and Compensation Committee based on the actual reports. I don't have the funding percentages at my fingertips, but we can get that for you.
I'm going to come back to that because I'm actually going to dig into the report in just a moment for some very specific questions that I have.
Okay.
So I will come back to that, I promise. Can you refer to,
I'm sorry, just on that question, you're asking if we've funded the full, the 100% of which obligation? The ERISA obligation?
so I'm trying to understand if a regulatory asset under rate making principles is appropriate. And I'm not referring to GAAP. I understand.
No, yeah.
And I'm not quite clear how a regulatory asset for rate making principles is appropriate as of yet.
Okay. So sorry, what exactly is the question though on the funded, what am I comparing what am I using as the basis for the funded definition?
So
ERISA?
I guess that's part of my questions to you. What justifies the regulatory asset having been established? And I would assume based on the discussions that we had on Tuesday, where we discussed the general concepts surrounding regulatory assets, the accounting literature, which was then referenced as being more applicable to GAAP. We talked about how GAAP has the footnote disclosure, and I'm sorry if I feel like I'm testifying here. I'm just repeating back what I thought I remember. The GAAP financial statements stated that there were no carrying costs tied to the OPEB obligation. So the GAAP said it was treated as a regulatory asset with no carrying costs. I'm trying to reconcile the GAAP accounting treatment, which I do clearly understand, and the rate-making principles, and I'm trying to understand why it's a regulatory asset.
Okay,
I would imagine it would be if the full amount that exists is refunded, the full amount, and it exceeded the minimum obligation, I would think that could make some sense.
one moment. So what we're doing here is taking the projected benefit obligation.
Yep.
We're then backing out the fair value of the assets. That right there does show that we are underfunded. However, included in that projected benefit obligation is actuarial gains and losses, which are not cash expenditures. They're estimates of future expenditures that are going to happen. We're backing that out. And when you do that, that's what's showing the funded status. And that funded status that's the component piece that we're asking for within rate base.
Please hold that thought, because
Sure.
you're now, I think, about to tackle or touch upon the questions that I have on the expenditure that's included in the revenue requirements, not necessarily rate base. So if we can
Sure.
come right back to that. So if you can refer to Exhibit C 316C, as well as the Exhibit SCG CBP 11, and I'm going to specifically refer you to page 17 to start.
So 316C.
Yes.
And then what was your other reference?
It's the PricewaterhouseCoopers report. It's Exhibit SCG.
11?
Yes.
Do you know what page?
I'm going to start on page 17.
I'm here.
So during the SCG panel, one of the questions that I had posed I'm sorry, during the CNG panel, one of the topics that I had posed a few questions on was to understand how the expense was derived. Do you recall that?
Yes.
Do you believe that the process is the same for the expenses for both CNG and SCG
For the expense,
expense?
so I believe so, yes. However, the comp and benefits panel would be the best to confirm as this is done by actuaries. So this isn't done by calculation, that was done by myself.
Understood. So right
But the
now,
methodology should be the same between the two entities.
okay, right now, what I'm hoping to do is to walk through and reconcile C316C as well as the report.
Okay.
So if I attempt to do that, am I correct to understand that it's like the second section down, reference to service costs, interest costs. If I look over at the 2024 column, I see 5.798892,
Yep.
and that would agree from the PwC report to the exhibit C316C.
Yep. Yep.
And am I correct to understand that all of those numbers for pension would agree to that section?
5799 agrees to 3116, 7085 agrees to 3116, 102 agrees to 316, and then 954 agrees. Yes.
So
230, yep.
the expense calculation is going to take an average between the two, not an average, a proportion between the two, given the rate year that we're working with. Is that correct?
Yes.
So that's pension. If I jump to the next section down on C316C, it's OPEB.
Mhm.
Would that be generally the same, but applicable to page 18 instead?
It should be, however, as described in our response to RRU 278, there's an error in that process in our initial filing for SCG, and we're going to correct that in LFE1.
I did not pick up on RRU 278. Do you know how much the correction was?
EOE 544 indicated it was, I have an adjusted amount of $2,861,
$2,000.
roughly.
When I attempted to take the numbers and use WPC 316C and use the exact same approach to calculate the amount, my difference is a bit different. Can we look at this together?
Of course. Apologies, I said RRU 278, but as I pull that up, I'm not seeing the correction I recalled. One moment. I do recall that we've committed to a correction and it is reflected in EOE 544, but let's walk through it together.
Sure. So. I'm being asked to ask if you can provide which line item in EOE 544.
What I was looking at was page 2, numbered line 14. Although as I mentioned, that was not the correction I was recalling. I could have sworn we identified this in response to a discovery request. I'm struggling to locate that now.
Yeah, maybe that's the. I guess I will offer if you would prefer to do a late file and basically fill in the same information that would exist in WPC 316C to derive what the correct amount would be. Remit that and then do a comparison so we would understand the impact.
Yeah, that works. Probably easier than doing math together.
I can appreciate that.
Okay, so we're up to late file exhibit 53. Mr. Parent, if you could summarize for me, please.
It would be a revised SCG WPC 316C for OPEB. That reconciles to the PwC report.
That reconciles to which report, please?
The CBP 11. It's the PwC actuarial report.
And Mr. Parent, if I could make 2 comments. One, I think we expressed in our direct testimony and potentially also the direct testimony of the Compensation and Benefits Panel that we intend to update our projection of pension and OPEB based on the most recent actuarial reports that are available.
And when will that occur?
In LFE 1. And then secondly, it sounds like you had an answer you were expecting to see here. Would you mind sharing that so we can compare notes?
Am I allowed?
And it's okay if.
No, thank you.
No problem.
I follow my lead.
We'll make sure you calculate it and then we'll work from there.
Sorry. Chair, there were 2 other late file requests from the CNG panel, LFE 25 and LFE 27 that I would also like to have provided for SCG.
Okay, the materiality thresholds and the calculation of the ESM results. So those become late file exhibits 54 and 55.
Thank you.
I'm sorry, Mr. Parent, before we move on, did we mark a late filed exhibit for the update to WPC 3-16C? Because Mr. Hurwitz then mentioned it was going to be part of late file 1 update.
I'm sorry, I marked it as late file exhibit 53 as I think it's both the revised schedule for OPEB, but also showing how it reconciles to the actuarial report.
Okay,
Is
I
that-
just want to make sure that's consistent with.
I actually would prefer it. It'd
Okay.
make it easier to follow it through and
That's fine. I just wanted to make sure we were clear. Thank you.
Thank you.
that's all of my prepared questions, but I don't want to disregard my comment about coming back to Ms. Van Lulen's comments if she wanted to pursue that any further. This had to do with the regulatory asset, if there was anything further that you wanted to share.
I've said everything.
I understand. EOE is complete. Thank you.
Thank you. Attorney Anaweji. Attorney Wright. Commissioner Karen.
Yeah, thank you, Madam Chairman. I had something I jotted down just shortly. I think it was concerning the amortization of we were talking about, avoiding a steeper rate cliff by using the 10-year amortization instead of, I can't remember if it was a 3 or a 5. What kind of rate cliff were we talking about if it's a shorter amortization period? Some kind of illustration, put in context if you could.
So the size of the regulatory liability in question is just a hair shy of $68 million. We proposed a 10-year amortization period, which produces an annual amortization to customers' benefit of approximately $6.8 million. As I understand it, the OCC's revenue requirement witness proposed a 5-year amortization period for this same regulatory asset. And just by convenience, that means it would be twice the annual amortization and by extension, twice the annual rate cliff. So if the OCC's proposal were accepted, by our calculation, there would be a $13.6 million rate cliff in 5 years, give or take.
Thank you, Mr. Vice Chairman. Thank you. I had a late file at the end of the CNG panel that I would ask to be extended to the SCG company, and it was late file 29 about expense adjustments. So if I could ask that that be posed for SCG as late file exhibit 56.
Of course.
Okay, thank you. Attorney Venora, do you need a moment to consider reject?
If we could, please,
Okay,
just a few minutes.
okay. We will recess until you come back. Okay, Attorney Venora?
Yes, thank you. We have nothing further for this panel, no redirect.
Thank you. Then this panel is excused and I will call up the Office of Consumer Counsel's panel and Attorney Venora, Attorney Vaughn, you are up first for cross-examination. Okay, I will remind Mr. DeFever that he remains under oath and Attorney Wheel, any preliminary matters?
No, I don't think for the record, James Howard Slagle for the OCC. No, I don't think we have any preliminary matters, but we'll go ahead and have him adopt his testimony.
Please.
Thank you. Good afternoon, Mr. DeFever.
Good afternoon.
Did you file initial testimony on February 8th, 2024, sir rebuttal testimony on March 13th, 2024, and interrogatory responses pertaining to the Southern Connecticut Gas Company in this proceeding?
Yes.
Do you have any corrections or amendments to any of those filings?
No,
Do you adopt those filings as your sworn testimony in this proceeding?
I do.
Do you recall testifying in this proceeding on Tuesday, April 23rd, 2024, and responding to cross-examination from authority staff at EOE, as well as counsel for the Connecticut Natural Gas Company?
Yes.
As you appear today to respond to cross-examination related to your testimonies and discovery responses pertaining to SCG, do you adopt your in-person testimony from Tuesday, April 23rd, 2024, and stipulate that if asked the same questions again, your answers would be the same, with the exception of any numerical figures such as dollars or personnel headcount that differ between the two companies?
I do.
With that, Mr. DeFever is available for cross.
Thank you. Attorney Venora?
Thank you. Thank you, counsel. I know we're noted for an hour of cross, but I expect in light of the adoption of the testimony, this will be quicker, just for planning purposes. Mr. DeFever, good afternoon.
Good afternoon.
Mr. DeFever, have you ever authored a lead lag study?
I have not.
Okay, but you've reviewed them, correct?
Correct.
And have you ever reviewed them in any states outside of Connecticut?
I'm not sure.
Okay, do you know if you've reviewed them in Massachusetts, for example?
I may have, but I really am not sure.
Fair enough, that's fine. I'm going to ask a couple questions on your CNG, your SCG direct testimony, starting at page 6, lines 3 through 6. And you state there that non-cash items should not be included in cash working capital because, quote, CWC is necessary for funds to bridge the gap between A, when the company needs to outlay cash to provide service, and B, when cash is received to compensate the company for service. Is that correct?
Correct.
And on page 7, lines 15 to 16, you state, quote, I recommend the removal of all non-cash items from the calculation of cash working capital, correct?
Correct.
And to accomplish that, did you refer to the company's revenue requirement model in this case and specifically schedule SCG B-4.0A work paper, which is the schedule that shows the company's cash working capital request?
I believe so.
I think, and you've captured that, I believe, in developing your exhibit JD-1 Schedule B-2, right?
Correct.
So from this list of items, I think as we discussed the other day, you recommended removing 3 items, which were depreciation, amortization, and deferred taxes from the CWC calculation on the basis that you view those items as non-cash. Is that right?
That's correct.
And all of those 3 items have the effect of increasing the cash working capital requirement in the company's request, correct?
Correct.
Okay. And you didn't recommend to remove any other accounts from the cash working capital calculation, correct?
That's correct.
And in deciding which accounts to remove, did you apply any criteria as to what should be removed from the company's computation, or did you rely primarily on Pura's treatment of cash working capital in its decision in docket number 220808?
No, I relied on my experience with this issue. I would say for the past maybe dozen years, we've argued this issue, and those were always the 3 items that we discussed in our testimony.
Okay. Now, does the company's schedule in your exhibit JD-1 Schedule B-2 also include line items for uncollectible accounts and net income retained?
It does.
And because these items show as negative numbers on your schedule, in the case of uncollectibles, I think it's a negative 3.055 million. And in the case of net income retained, it's a negative 2.101 million. These items have the effect of reducing the cash working capital requirement, correct?
Correct.
Is the allowance for uncollectible accounts a cash item?
I don't think so. This is something I have to look into historically, how this has been treated. I was blindsided that there are items that were considered that that anyone had considered to be non-cash items in here that I hadn't taken out. So this is something I'm going to have to look into.
But do you have an accounting background, Mr. DeFever?
I do.
So with respect to uncollectibles, is there a cash outlay for uncollectible accounts on the part of the company?
No.
So at the time it's booked, I mean, it's essentially non-cash in that regard, right?
Correct.
Okay. And in that regard, it's similar to the depreciation expense in that there's no cash outlay when the company records monthly depreciation expense, right?
Correct.
Okay. In the case of net income retained, is that a cash item?
That's something else I'm going to have to look into.
Okay. Similar to uncollectibles, is there a cash outlay when net income retained is recorded on the books?
No.
So in that regard, it's similar to depreciation, right? In that it's a non-cash item under your definition.
Again, that's something I want to look into. I mean, I understand the claim that I'm being inconsistent on this.
Mhm.
So I want to spend some time and be consistent.
Right.
You know, so I want to look into these things. I want to look at how they've been historically treated, what the arguments are on both sides. Again, I had only, up till this point, I had only really looked at the three that I took out.
Right.
So I don't want to say speculate, but I want to spend some time before I do
What was,
those.
so in focusing on those three items, and I know OCC has advocated this for a number of rate case cycles, and until the UI case, that was not adopted, but was that your only focus in terms of identifying the three items that you thought qualified as non-cash?
Well, was what my focus?
The UI order in docket 220808, was that the only
Oh, no.
source?
I'm gonna just
Oh.
object that this was asked and answered. I think the same question
Okay.
was answered before when
Maybe.
Mr. DeFever referred to his experience.
Okay, I'll rephrase. So in your experience, have you ever looked past the prior testimony that OCC submitted or advocated to look at each of the line items to determine, you know, whether or not they are similar to the three items you've historically advocated to remove from the cash working capital allowance?
No, I haven't, and that's what I'm saying. And that's something I need to do.
Okay. Wouldn't you have done it? Shouldn't you have done that before you submitted your testimony?
Again, this has always been framed as like the battle of these three items. If you read any of my testimony, it lists these three items and said they shouldn't be there.
Right.
So I hadn't really looked at the big picture. I mean, I don't want to say I didn't look at the big picture, but I didn't look at each other item and say, question whether they should be in there or not.
Okay.
But I agree, I should do that.
Yeah, because by removing the subset of items that you identified as non-cash, those three, you know, depreciation, amortization, and deferred taxes, you've picked only the items that have the effect of reducing the company's computation of cash working capital, right?
Correct.
And the items that you left behind did not remove, meaning the ones two that we just talked about, uncollectible expense and net income retained, those are ones that would increase the cash working capital requirement, correct?
Right, but I also may have left out some that went the other way as well.
But you didn't. The only three that you took out were the three that we talked about.
Okay.
Right? Because I'm looking at your schedule. Those are the only three that you take out.
Those are the only three I took out. I'm saying the other ones that I may have missed ones going the other way as well.
Okay, so there could be others beyond uncollectible and net income retained that would work in that direction, correct?
Right.
Okay. I think that's all. That's all we have.
Thank you.
Thank you.
Authority staff? Oops, I apologize. Mr. Baker?
Thank you for indulging me. I know I wasn't on the list, but Mr. DeFever brought up a point well, Attorney Venora was crossing him the other day. With respect to the call before you dig program, and from the transcript, you made a comment back stating it's not necessary for ratepayers to pay for it, meaning the call before you dig program. I guess I'd like to delve into that. You could explain to me what your reasoning is on why they shouldn't pay for that program.
Yeah, my understanding is there's a statute that says ratepayers shouldn't pay for it, that shouldn't be collected from ratepayers. Not dues to industry and non-industry associations.
Okay. can you explain to me how this is a due? I guess I'm misunderstanding.
That was our, we requested that from the company to provide us the organizations to which they're providing dues, and this was provided to us by the company.
All right, and so the fact that in state statutes, it requires the company to pay for these items, you don't think that should have any bearing on it?
Well, that's, if it's in the statute, I mean, it's not up to me. That, you know, I mean, that's,
Okay.
I don't have an opinion on, you know.
Okay, I just didn't understand
That
that.
was the reason I took it out.
You just
because-
assumed it was a dues.
No, I
kind of
didn't
like-
assume. I was told by the company.
Like America gets, okay, all right, fair enough. Thank you. I have no further questions.
Okay, Attorney Noeg. Attorney Wright. Attorneys Wyman or? You do, okay.
Good afternoon, Mr. DeFever.
Good afternoon.
My cross last time took less than a minute. I'm thinking this is going to be the same. Last time I referred to RRU 699 for CNG, but I'm referring to OCC 753 for SCG. For the following quote, am I correct to understand that this is solely responding to gap accounting and not rate making? And the quote that you included in your response was, based on limited review of schedules B6 and B8 and the company's response to RRU 200, I am unaware of any inconsistencies between the company's treatment and accounting standards.
Correct. That was only from an accounting perspective.
Does the statement mean that you agree with the company's treatment of costs for the defined benefit plan and its classification as a regulatory asset?
It does not.
Thank you.
Thank you.
Thank you.
Mr. DeVito, welcome back. Just a few minutes ago, you were having a conversation with Attorney Venora concerning some of the non-cash items. How are you planning to address some of the other non-cash items you feel you've missed? Will you be getting back to us with a supplement to your testimony? Will it be a late file exhibit?
I was thinking by the brief, we should have that would be included in the brief.
Addressed in the brief.
Yeah.
And you expect that what you're going to try to do is look for consistency in your testimony.
Right. I want to look at it because my testimony is based on these being non-cash items and that they don't fit the definition of cash working capital. So I want to look at these and see if that I want to be consistent. Yes.
Okay. Thank you. That's it. I'm Chairman. Thank you.
Mr. Vice Chairman. I don't have any questions. Attorney Wheel, do you need a moment? Attorney Talbot Slagle, do you need a moment to consider redirect?
I have a brief redirect that we don't need a moment to consider, which I know is Mr. DeFever's favorite thing for me to do. I just have one question, and that it's a follow-up, I think, to the question that Commissioner Karen just asked. When you've worked with OCC in the past, traditionally when OCC files a brief, do you provide an updated schedule similar to Exhibit JD1 that gets filed with that brief?
I do.
And do those updated schedules typically include any adjustments that OCC makes to its initial position as filed in our initial testimony and reflected in your initial testimony?
They do.
So would that be the place where any adjustments to your cash working capital recommendation might be reflected?
Yes.
Thank you. That's all I redirect.
Thank you. Panel is excused. Move to our tax panel. Call up the CNG panel, tax panel, and ask Pura staff to approach the cross-examination table, please.
Chair Gillette, while the tax panel's getting settled, I just wanted to react to what Attorney Wheel said about updating Mr. DeFever's testimony and a schedule to the brief. My recollection is when they do that in the brief, it tends to be technical corrections and such. So I think I'm just reserving the right to potentially object to that process, because if it's a substantive change to what he's put in testimony, if we don't see it until the brief, we will have no opportunity to respond on the record. So, I mean, right now his testimony has been submitted and adopted on his position. So if he were to change that in the brief, that potentially is out of order.
Attorney Venora, I will note your reservation of objection. My reaction initially is that the close of the evidentiary record is what it is, and any attempt to insert evidence after that date by any party or intervener is discarded by the authority in its consideration. Typically, our practice is not to strike anything from the record, but rather to make a statement that we are giving it whatever weight it's due. And if it's after the close of the record, that weight is presumably negligible. But they would not be the first party or intervener to try to insert evidence after the close of the record. So I will note your reservation of objection and offer that response for now. Okay, we're at the tax panel. Attorney Venora, Attorney Vaughn, do you want to introduce the witnesses, and I will swear in our new witnesses?
To the panel members, would each of you, beginning with Mr. Mayo, please state your full names and positions for the record?
Yes, Luis Mayo without O, and indirect tax manager.
David Bieber, Jr.
Let's try that again. David Bieber, Jr., Vice President Tax, Avangrid.
Jacob Hurwitz, Senior Director of Revenue Requirements at Avangrid.
Andrea Van Lilling, Networks Controller.
Okay, and we do not have Melissa Dorsey.
We do not, no, but Mr. Bieber will be adopting her materials.
Okay, thank you. If I could ask our new witnesses to please raise your right hand and I'll administer the oath. I've already sworn you. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you. Attorney Vaughn.
Ms. Van Luling and Mr. Hurwitz, you were previously sworn in. Mr. Bieber and Mr. Mayo, as part of your preparation for this docket, did each of you co-sponsor direct testimony for this proceeding, which was marked as Exhibit CNG-TP1 through 3 and Exhibits SCG-TP1 through 4?
Yes.
Yes.
Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do either of you have any updates or corrections to your pre-filed testimony or interrogatory responses not previously identified for the record in an interrogatory response?
No.
I have corrections to the testimony.
Please explain.
For CNG, on page 13 of 16, line 12, there's a reference to SCG. It should say CNG. On the SCG testimony, on page 4, line 7, there's a reference to a CNG docket 1805-16. It should reference 17-05-42. Similarly, on page 12, line 6, there's that same need for a correction to 17-05-42. And finally, on page 4, there's a reference on line 4 that has the word continues, and the word plans should be substituted for continues.
Thank you, Mr. Bieber. Subject to those corrections, do you adopt your pre-filed testimony and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
I do.
Thank you. Mr. Bieber, have you also reviewed responses to interrogatories in this proceeding sponsored by Melissa Dorsey?
I have.
And do you adopt those interrogatory responses as part of your sworn testimony in this proceeding?
I do.
The panel is available for cross-examination.
Thank you. We'll begin with Mr. Paff on behalf of authority staff, please.
Good afternoon, panel.
Good afternoon.
My name is Ryan Paff. I'm a consultant to Pura and Pura staff. I have one substantive issue to review with you today that's related to your valuation allowance proposal. The first question is the Connecticut Fixed Capital Investment Credit, which you use the acronym FCIC in the tax panel testimony, correct?
Yes,
And that's a state program designed to provide tax credits to companies that invest in tangible property within the state.
that's correct.
How long has this program been available to the company?
The credit has been around for a number of years. I can't tell you exactly how many years, but it's a long-standing credit opportunity.
And since you can't tell me when it was implemented, you probably can't tell me this, but I'll ask you it anyways. When was the first rate case in which the impact of the credits would have been incorporated into the company's revenue requirement?
I don't have that information.
The credits are calculated as 5% of a company's annual fixed capital investment. Is that correct?
It's a 5% credit, but there's other impacts from a revenue requirement standpoint, like the federal income tax offset associated with that.
And the FCIC expire within 5 years if the company doesn't use them, correct?
That's correct.
Has the company ever been able to take advantage of these credits?
Yes.
Can you please go to page 10, line 8 of the tax panel testimony?
One moment, please. I have it.
And in this area of your testimony, you state the customers received the value of the state tax credit benefits in the previous rate case. You see that statement?
Yes.
You continue in your testimony by stating that the tax credit benefits extended to customers in the previous case were reflected in Schedule WPC-3.31 from Docket 180516. Is that correct?
That's correct.
How would the tax credit have been calculated in the 2018 case? Would it simply have been the level of Connecticut investment assumed for the rate year multiplied by 5% with some federal tax offsets like you discussed? Or
That would have likely been the way. I don't recall off the top of my head, but that would have been basically, I mean, there's a little more work involved. First of all, you have to look at ultimately to sustain the credit, not every type of expenditure qualifies. And so we look at the expenditures, we identify which ones we think qualify, and then we would, of course, apply the credit percentage to those expenditures and with the FIT offset.
But it would have been based on a projection of the investments for the rate year. Is that accurate?
Very likely.
Has the company ever incurred more investments in the rate year than they anticipated in the rate case filing?
I'm sure it may have.
And in that case, would the credit and in that hypothetical, would the credit that the company calculated for purposes of the rate case been understated relative to the actual?
I would say no.
Can you elaborate?
Well, there are a multitude of costs that and benefits that we reflect in a rate case that deviate from actual. If we reflect these items in operating results, then to me, the presumption is that customers did benefit from them.
But just talking about the FCIC specifically, the number that the company would have been able to use as a credit would potentially have been more than what was embedded in rates if their investments were more. Is that correct?
Well, the benefit in rates doesn't have to do directly with utilization initially. It has to do with generation initially.
And you're saying that because the credit is established when it earned, is that?
That is correct. From a financial statement and regulatory perspective, our
That is-
initial step would be to recognize the value of the credit as earned or generated, not when ultimately claimed on the return.
So if I understand your testimony, there has been variance in previous periods between what the company calculated for purposes of its revenue requirement in a rate case and what it actually incurred as far as the FCIC, or what the FCIC ultimately resulted in.
Well, I guess it depends on what you mean, what it resulted in. I think what I said is that it is reasonable to believe that there could be a difference between the credit reflected in a rate case and what we may have ultimately experienced.
Okay, thank you. And has the company ever previously sought any sort of true-up mechanism for the FCIC in a previous rate case?
I'm not sure what you mean by true-up mechanism.
I mean, if the amount assumed in and embedded in the revenue requirement was X, and the amount that ultimately resulted from the FCIC was Y, the company comes in and seeks to be made whole between X and Y.
I don't think that's what we're doing in this instance or in the past.
Okay, but hasn't been an instance like that you're aware of from the past?
I'm not aware of such an instance. I think it's important to note that the company seeks to recover its tax costs and provide customers with the benefits that it enjoys. And I think what we're proposing or stating in this testimony is that it's clear when you consider the rules that we have to operate under that the company is enjoying less than two benefits. We have provided customers with two benefits, a fixed capital credit benefit and a repairs tax deduction that is impairing the full realization of the credit benefit. And so all we're proposing here is that we ultimately get to recover or share the same benefits that we're experiencing.
Do you know if the FCIC was included as a distinct line item in the revenue requirement calculations for the previous rate case?
I'm not aware of whether it was a separate line item. I am fairly confident that it was substantively included.
And the last rate case was resolved by settlement, correct?
Yes.
And was the revenue requirement figure a black box number?
I was not a participant in how that number was derived, so I have an answer for you to call it a black box settlement or not.
Are you aware of any provision in the 1805-16 settlement agreement that guaranteed rate recovery of any expired FCIC?
I'm sorry, would you repeat that question?
Are you aware of any provisions in the 1805-16 settlement agreement that would have guaranteed rate recovery of expired FCIC?
I'm not aware that any potentially expired FCIC was identified, so to provide a complete answer, I would have to say that I'm aware of neither such item included, nor am I aware of anything that would have prompted such inclusion. Settlements, I would believe would generally identify and speak to things that were being experienced. So the absence of any such language would not necessarily be representative of anything concerning this.
So I guess that's a no, ultimately.
I'm not aware of anything.
In discovery response to RRU 761, which we have projected, I believe Ms. Dorsey and Mr. Hurwitz sponsored this request. But within this request, the company stated that the pre-grossed up revenue requirement impact of the company's proposal was $46,604. Is that correct?
Yes.
And is the amount that ultimately impacts customer rates the pre-grossed up revenue requirement number or the post-grossed up revenue requirement number?
Post.
And what would the amount be for the post-grossed up?
We'd have to calculate it, but I would imagine it would be approximately around 1.4 times the 46.6 or $46,604.
So it would be this amount times the revenue conversion factor. Is that how it works?
Yes.
And just for the record, since you're all in front of computers, would you mind doing that math so we have it?
One moment.
The amount is $68,141.
And is this amount quantified anywhere in your testimony?
I don't believe so.
And the amortization period for this was 40 years. Is that correct?
The case assumes a 40-year amortization, yes.
And that would mean that customers would continue paying for this for the next 40 years. Is that correct?
It does. It is correct. Excuse me.
And My math was based on the 46,000 amount, but would the total amount then be the amount that you just stated times 40?
The customer is receiving a substantial benefit in the form of a rate-based credit for the repairs tax deduction that is affecting this item. And so while, yes, there would be a multi-year charge associated with this amount, the customers are receiving a benefit that's larger than this charge.
I appreciate that. And I know that you explained much of that in your testimony, but would what I just say be correct? I'm not sure you answered the question directly. Would it be that amount times 40 years? And that would be the total amount that would be charged to customers over that period?
Since the amount that we're talking about represents actual write-offs, that would be a correct statement relative to actual write-offs.
And again, since you just did the post gross up amount for the single year, could you also read into the record what the post gross up total amount would be?
Bless you.
$2,725,651.
And are you seeking to establish a regulatory asset related to this item?
To expand on the answer to the first question, our fixed capital credits, let me pause for a minute.
Mr. Paff, the authority had several findings with respect to what constitutes a regulatory asset in docket number 220808. So I'm going to answer your question without using the term regulatory asset. The company is seeking to recover this amount in this case. I would add that ASC 740 requires the company to record certain amounts related to the valuation allowance.
Where is the unamortized balance in the company's proposal, or where can I find the unamortized balance in the rate filing?
I don't believe the filing shows the unamortized balance. The plant model would include the impacts of the amortization we have testified to.
So does the unamortized balance have no impact on rates at all?
Not in this case.
And when you say not in this case, what do you mean by that?
As Mr. Bieber described and is reflected in his testimony and I think some data request responses, we're only seeking to recover credits that have either already expired or that will expire before the beginning of the rate year. So to the extent additional credits expire in the future, that could have an implication in future rate cases. But in this case, this is all we're seeking.
So I apologize if I'm being dense on this issue, but I'm not quite understanding how you're amortizing something that doesn't have if there's something that has approximately, was it about approximately $2 million total?
Over 4 decades.
Yeah, but I just wanted to confirm it was approximately $2 million. Is that correct?
The number Mr. Bieber read into the record a few minutes ago was $2,725,651 over 4 decades.
So there's that $2.7 million and you amortize 60,000 or whatever the number was every year for the 40 years. Where is that 2.7 million on the company's books?
It would be reflected in the balances on Schedule B 7.0.
So it's getting rate-based treatment.
We've also included the offsetting credit on B 7.0.
So just to confirm, there's a balance on B 7.0 that is then backed out. And so there's zero impact on rate base related to this item.
To clarify, there's the rate base reduction for the VA, and there's the rate base increase for the requested recovery of the VA.
And these net to zero.
To the extent we have not written off the credits, the presumption would be zero. But if a credit were written off, then we would only have the unfunded.
And that would be an increase to rate base.
I prefer to think of it as it substantively represents a credit that we never got to enjoy, that we already gave the customer.
But I'm not trying to mince words. I just want to make sure that the record's clear. It would have the ultimate impact of increasing rate base.
I believe that that is true, whereas at the same time, there's a substantial decrease to rate base that exceeds that value because of the aggressive, I'll call it, rather than aggressive, customer-focused acceleration of the repairs tax deduction. So to look at one piece without looking at the other piece sort of does not complete the picture. I think you have to look at it in totality, and what's happening in totality is that there's a substantial rate base credit for customers.
And I appreciate that. I know that you included that in your testimony, but obviously I didn't see these numbers that we're discussing in your testimony. So I'm trying to complete the picture for the commissioners. In regards to RRU 761, the revenue requirement impact that is discussed there, does that only include the impact of the amortization without including the impact of the return earned on the portion that's in rate base?
Your path, that's correct, but we're kind of struggling here because as reflected in table 1 of the tax panel's testimony, we're giving customers the benefit of over 162 million of tax basis repairs deductions. That has an effect on our accumulated deferred income tax balance. And so the focus on one side of the equation while ignoring this extremely material benefit that we're giving to customers, it's just causing us to struggle.
But again, I understand that, and I appreciate that. But I do know that you've discussed that at length in your testimony, obviously, and that's in the record. So I'm trying to, as I said, I'm trying to complete the picture for us, but most importantly, the commissioners. And so I guess a question I would have is, why was the impact of on rate base not incorporated into 761 subpart B?
I think we have a few points in response to your direct question, so hopefully this is helpful. Reading the question, I think you point to our proposed, the question asks for our proposed revenue requirement. And so I think what we did is we put in what we propose for revenue requirement. And I think with regard to providing a complete picture for the commissioners, which we agree with, wanting to do the same thing, I think it's important to note that as the repairs tax deduction, we believe is the proximate cause of the thing you're concerned about. The company does have the option prospectively in any given tax year of choosing to follow the book method of repairs, which would provide a substantially less deduction, which would raise our taxable incomes, which would cause us to perhaps not have to have this issue. So we remain open to that if you think that's a better option.
So in terms of my initial question, as far as why the subpart B did not include the impact related to the revenue requirement impact related to the impact on rate base, did you respond to that and I missed it? I apologize if that's the case.
I think I was attempting to be responsive. I think ASC 740 requires us to record the valuation allowance, as we've stated, and our proposal is simply to recover the amount that was written off, as we've stated. So I think in an effort to be responsive here, we provided the amounts that seemed to substantively respond to the question asked. That was the intention.
But this doesn't incorporate all of the revenue requirement impact of the expired FCICs. Is that correct?
I think the question focuses on the fact that there's an amount included in rate base on the debit side, and I think the question misses that there's a credit in rate base as well. And so I believe that, you know, if we're talking about the debit side, we have to talk about the credit side, and together these impacts are infinitesimally small relative to the tens of millions of dollars of credit and rate base relative to tax acceleration implemented to help customers.
Thank you for that. Just focusing on the company's proposal itself, though, I believe you said that the $2 million that we calculated before, approximately 2 million, that we calculated before, that was a component of rate base, or I should say that would increase rate base. Would that have an approximate revenue requirement impact of 200,000, give or take?
To repeat, there are tens of millions of dollars of rate-based credit coming through for the customer favorable treatment we were giving them in the form of repairs tax deductions. Anything we've included relative to what we're speaking about relates to the economics of, I'll call it, customers getting a benefit. And the benefit they're getting is substantial. Expanding on that, it would be, had we not done this, the revenue requirement impact would have been substantially higher for customers. And so what we're doing is a huge win for customers.
I can definitely recognize that's the company's position. I'm just trying to understand the actual revenue requirement impact of this proposal specifically. And generally, impacts on rate base have about a 10% or so impact on the revenue requirement. Would that be an approximate revenue requirement impact here as well?
I agree that rate base obviously has an impact on the revenue requirement, and depending on the specific change to rate base, that can be in the range of 10%. What we're really struggling with, Mr. Paff, is you keep saying we're trying to complete the picture, and I think that the sum total of the picture, if we had not made this proposal, our revenue requirement would have been substantially higher. And to fixate on only half the equation, it really feels incomplete to us. And my apologies if I'm missing your question, but we'd be happy to do any additional math that you'd like, but.
Yeah, Attorney Venora, is there a formal objection? I feel like I've listened to the question be asked like 20 different ways, and the witness keeps saying that some version of, what was just said. And I think we're stipulating that the testimony has in it already the company's position. So just a formal objection.
No, I didn't object because I thought Mr. Pfaff had questions, and I think the
Okay.
panel was answering as best they could. I mean, if there's an additional schedule or exhibit that he thinks he needs to illustrate this, we could offer that up, but I wasn't inclined to object to the questions.
Okay, okay. Let's do this. Let's take a break until 3:15. And we'll resume this cross. Thank you.
Yes. Then the outcome is very fast. But before the security and getting the pay. If you will not get benefit of the LTD, if you have and then we have 85,000 and I used to increase costs.
I'm not calling.
So.
Okay. All right, I think we are back. So we can go back on the record and Mr. Pfaff, you can resume, please.
Thank you, Madam Chair. I believe I would, I believe the most efficient route might be to take a late file for the series of questions that we had right before the break. So if it's acceptable to the commission and the company, I'd like a late file that details the revenue requirement impact of the company's valuation allowance proposal. And that would incorporate all revenue requirement impacts. And please break those components out.
That works for us.
Thank you.
Thank you. That is late file exhibit 57.
In response to RRU 762, well, actually, I'll start with what the request was. In RRU 762, I asked for the company to state whether the company is aware of any jurisdiction in which a similar recovery mechanism was allowed by a public service commission. And if the answer is affirmative, provide copies of the orders for the relevant cases. In response to this request, the company stated it was aware of one utility, Essential Utilities, whose audited financial statements reflect a recoverable regulatory asset for a valuation allowance. Do you see that response?
Agree, that's what we testified to or reported in the data response.
Can you explain why the company's proposal here did not lend itself to a regulatory asset? In other words, why a regulatory asset wasn't established for this proposal?
I think we think the best way to respond is to address your question as part of the late file that you just asked.
Fair enough. Could I have Could I request another late file, which would be the journal entries related to this proposal? So that would be how the FCIC is originally recorded on the company's books, and then any subsequent entries necessary to get to the point that of the current proposal.
For the rate-making purposes,
Correct.
Mr. Pfaff, it was FCIC?
FCIC, yes.
I'm sorry.
FCIC, correct.
Okay.
Thank you. And Ms. Van Looling, if I could get both the accounting journal entries and the rate-making journal entries, that would be helpful. Thank you for clarifying that.
And that's late file exhibit 58.
Those are all my questions. Thank you.
Thank you. All right, Mr. Bakari, please.
Panel, could you turn to your response to RIU 313?
I have it.
Okay. Could you explain for the calculation of rebate if CNG normalize or flow through the deferred tax effect of repair tax deduction?
CNG normalizes tax repairs deductions.
Are you aware of any Connecticut utilities that does not normalize but flow through the effect of deferred tax related to repair tax deduction?
I'm not certain. I know some years ago I saw in my water bill repairs tax deduction.
Okay. Subject to check, I believe you might be referencing Aquarian's settlement several years ago where they actually flew through the tax effect of repair tax deduction to their customers. Is that correct?
I'm not sure, but I know that repair flow through is a permissible way to treat repairs tax deductions. I've also testified to the risks and intergenerational inequities associated with flow through on that very subject.
Flow through is not, the fact that the tax deduction relates to repair tax deduction or expenses for tax purpose, that is not a violation of 168 normalization rule, is that correct?
Flowing through repairs tax deductions?
Yes.
Is it permissible and not violative to? You're correct. You can flow through repairs tax deductions without running afoul of the normalization rules.
Okay. If you look at that response, could you explain why the RTD for 2022 is approximately 50% more than the amount for 2021?
The deductions that we claim result from a sampling of what amounts to work order activity. And in the sampling of the work order activity, we have to evaluate the type of replacements that we identify. In some years, we'll have a sample that will have more benefits, and other years we'll have samples that draw less. And when we extrapolate, that produces more or less benefits. So we've seen volatility in the repairs tax deductions, which is another reason we believe flow through is inferior to normalization.
Okay. But flow through, subject to check, that would decrease the tax expense that's payers are responsible for, is that correct?
It won't permanently decrease the tax expense. It will just delay when customers have to pay back the company for repairs is just a temporary tax benefit. So anytime you flow through something, you're just creating a customer liability for the temporary benefit they enjoy. So it's not a real benefit because the repairs cost that the company bears is offset by a revenue amount. So ultimately, it's a zero.
To the, just for clarification, to the extent that you flow through, the impact is on rate base in that the deferred tax that will go by the same amount, is that correct?
Can you rephrase that?
If instead of including the DIT effect of repair tax deduction as a normalization adjustment, that amount will flow through to the tax expense, is that correct?
If your question is, if we flow through repairs tax deductions, would you have to remove the rate-based credit? I agree, because you would, there would be no basis on which to provide a rate-based credit because you're now flowing through.
And that would reduce the income tax expense for that year for the same amount. Is that not the corresponding other side of the equation?
The effect of flowing through would be to allow the company to, or it would produce a current tax expense impact without producing a deferred tax expense impact.
Okay. By not producing the deferred tax impact, that's a reduction to the company's tax expense for that particular period. Is that correct?
Most likely.
Okay. In your response to Mr. Purv's question earlier regarding repair tax deduction, you indicate that the repair tax deduction created a benefit to ratepayer. Could you describe the benefit you're referencing?
The benefit I'm referring to is the form of a rate-based credit for deferred taxes.
Okay. Does the RT deduction resulted in net operating loss of the company?
It might depend.
What was the basis for upon which the company cannot use the FCIC?
I'm sorry, say that again?
Why is it FCIC?
The basis could be, it may have generated more FCIC than it could absorb. It's not necessarily NOL driven. It could just simply be that the taxable income amounts don't sustain it.
Okay.
Could be a combination of factors.
Does the DTA resulting from NOL position offset rate base?
Would you say that again? I'm sorry.
To the extent that the company has a NOL position due to repair tax deduction, does the NOL position create a deferred tax asset that the company utilizes to offset rate base?
To the extent it has an NOL carry forward DTA, it would be in rate base, which would neutralize the acceleration associated with a non-monetized benefit. So it wouldn't harm customers. It would keep things consistent.
Okay. When did CNG first started accruing FCIC that were generated but could not be fully utilized?
I think the question, well, I'm not sure exactly when it couldn't first utilize credits. CNG has been around a bit longer than I have with regard to CNG, so I can't say for sure.
Okay. And I guess your response to Mr. Pavlet's file will indicate when the company first recorded the regulatory asset related to the FCIC that not utilized. Is that correct?
I think we can incorporate that into the response.
Okay.
So sorry, that's a new late file?
No, I'm asking them to augment the last late file. I believe later 57 was
The 58 is the journal.
58 to include when the company first accrued deferred tax asset related to the FCIC. My last question to the company, actually, it's not a question per se. Would the company be able to provide a worksheet that shows the calculation of income tax expense for 2022 and the rate year under the assumption that the deferred tax related to RT deductions are flow through and are not normalized?
For 2022 and
The proposed rate year.
the proposed rate year. We can do that.
Okay, so late file exhibit 59, got provide work paper showing calculation of income tax expense for 2022 and rate year under the assumption and
That the tax effect of repair tax deduction we are flow through, not normalized. You can include the revenue impact of either approaches if that's helps.
okay,
Chairman, that's all my questions.
thank you. I think that's it for the authority staff. Okay, OCC, please.
Good afternoon, Tom Wheel for the Office of Consumer Counsel. As you will soon learn, I am not a tax expert at all. I was just one follow-up, I think, from Mr. Pfaff's line of questioning, which I was struggling to follow. Mr. Hurwitz, I think that you said that the FCIC, both the offset to rate base and the credit to rate base are reflected in Schedule B70. Could you just direct me to which line that's reflected on?
Attorney Wheel. Schedule B 7.0 was provided at what I'll term the FERC account level. You can see the lines are labeled FERC 190, FERC 282, FERC 283, et cetera. The asset, the upward item is in FERC account 186, so Excel row 19. Subject to check, we think the offset is in line Excel row 15, FERC 190. We think it's a contra asset.
Okay. Could the company just maybe indicate that in that first late file exhibit that Mr. Pfaff, just for the benefit of those of us who are struggling to, to track all of this to the revenue requirement?
Certainly.
Thank you. I just have a few questions of my own. I'm laughing because I listened to the first panel, to the authority staff crossing to make sure I wasn't duplicating anything, and I'm certainly not, because my questions are much simpler. Turning to the initial testimony at page 4, beginning with the discussion about tax liabilities. So the testimony references the 2 tax liabilities that did exist for CNG, labeled the first labeled the pre-2018 liability and the post-2017 liability. Could you just explain in basic terms what caused those liabilities? I think I saw sort of an explanation on the SCG testimony, but I didn't see as clear an explanation on this, so I just wasn't sure if it was different.
So on the piece that is not the post 2017, there was a deferred tax remeasurement, and a simple example might be when in 2017 the tax rates went from 35%, the federal tax rate went from 35 to 21%. So if we had $100 temporary item, we would have had $35 of tax on our books. And because of the tax rate decrease to 21, we now only owe the government 21, but the 14 difference now becomes a liability to the customer. So the amount you see that's not the post remeasurement is that $14 in my example.
Okay. And that becomes a liability to the customer, meaning it needs to be returned to customers?
Yes.
Okay. And the reason for that, just so I'm perfectly clear, is that what was built into rates, whatever rate plan was in effect at the time that that tax change happened, had an amount built into base rates to compensate the company for that 35% tax rate?
I think of it as we recovered a non-cash expense in accordance with the normalization rules. And because the obligation to the government changed or was reduced in this case, we now no longer have that same obligation to the government, but the appropriate and fair thing to do is to return it to customers. It's just like if the situation were reversed and the tax rate actually increased and we were underprovided, it would be appropriate to now recover from customers that increase because now we have a higher obligation to the government.
Thank you. And is that this is sort of just a general question about maybe historical question for the company. Has that happened before? Has the company recorded a regulatory asset associated with a tax rate increase historically?
I can't say specifically with regard to the full historical legacy, but I can say that in the prior case, we did have a provision that said that along with Tax Act changes, that we would defer differences in state and federal income taxes as a result of changes in tax rates or applicable laws.
Okay, so then the kind of basis for the recording of this liability was a portion of the PURA decision and what set rates for the applicable period?
I don't know that it was pure prompted. I think, you know, we recognized when the rates changed that there was a substantial, a very good opportunity for us to return money to customers that we didn't need. And we just thought it was the right thing to do. That this was something that, you know, this was a monumental change, and companies all over the country had to deal with this issue. And
Okay, thank you. Yeah, I wasn't even specifically asking about this particular scenario. I was just trying to kind of wrap my head around the way it works from a rate making perspective. And maybe another way to ask it is the company seeking as a component of this rate case a standard from the authority that there be some adjustment, that to be allowed to reconcile differences in actual tax expense against what's allowed in rates?
I think that's a great question, and I think this gets back to what we were saying earlier about seeking to, as a principle, simply recover the tax expense that we incur, and that includes sharing the benefits that we receive as part of that net tax expense. So whether up or down, we just believe that the goal should be income taxes are just a cost that we seek to recover like other costs. And so we're just trying to be whole with regard to them.
Okay. Thank you. On page 5 of your testimony, there's just a reference. I'll read it out loud. It says, on August 30th, 2018, PURA approved the settlement reached between the parties in the company's prior rate case. Just for clarification, it looked to me like August 30th was the date of the settlement agreement, but not the date that PURA approved it. Can you confirm that?
I'm sorry, which line are you on?
Just a moment.
Okay. And would you restate your question?
Sure. Do you still need the line?
No, I see it.
Okay. Thank you. The question was just, when I looked at the settlement agreement that's referenced in this testimony, it looked to me like that date is the date that at the top of the settlement agreement, and the associated PURA final decision, I think, may have been in December of that year, or it was a different date than August 30th. So I was just seeing if that also tracks what you're looking at.
You could be right. I'm not sure. But that sounds like that's correct.
Okay. And in that agreement, I just have some questions sort of trying to understand the difference between the post 2017 liability and the pre 2018, the kind of two different treatments. So in that agreement, CNG agreed to fully refund the post 2017 liability, and that was the $7.12 million, and that was over the first 2 rate years. Is that correct?
Yes.
Okay. But then there was also the $11.873 million liability that's still being refunded. It was a 32-year period as of that settlement agreement, correct?
Yeah, and I may be able to help you with this if you try and understand timing. At a really basic level, the former liability, the one that is the result of a deferred tax remeasurement, there are federal tax rules that apply to the protected element of that. With regard to the post remeasurement, there are no such rules.
Okay. I actually, yeah, and I saw some reference to that in the SCG testimony, which obviously we'll talk about in the next panel. And that is sort of why I'm trying to understand how it happened in the past. So the federal rules, would those be with regard to the part that was returned in the first 2 rate years, or the part that's still amortizing into the future?
It doesn't pertain to the remeasurement piece. Pardon me, let me correct that. The federal tax rules apply to the deferred taxes. The other piece, the post-remeasurement piece, has to do with what was assumed in rates relative to, say, equity return. It's the tax on the return.
Okay. And just again, because I'm struggling to follow along, which of those is the 7.12 million the part associated with the equity return, or is it the 11.873?
The 7.1 is the piece associated with post remeasurement, so it doesn't have to do with our deferred tax liability. I think Mr. Hurwitz referred to it as a current tax liability, and I think that's a simple characterization.
Okay. And what is the federal standard that controls the amortization period?
It's the normalization rules, which require us basically to give back. This is a oversimplification, but you're required to give back the amounts ratably, which is generally like the weighted average book life. But that's, again, a very high level simplification.
Okay. So did that, and again, I'm sorry, I'm sure you've answered this several times. I'm just struggling with the terminology. Did that control the 2-year period or the 32-year period?
No, it controls the deferred taxes. So think of, maybe this is a way that can help. The deferred taxes are amounts that we have to pay back the government, largely pertaining to accelerated tax recovery. So a timing issue. So we may have claimed maybe 20-year depreciation for tax return purposes and say 38 years for book purposes. So we get this temporary benefit because we're allowed to deduct costs faster for tax return purposes than books. So that amount is calculated using the tax rates at which we expect to pay back the government. When the tax rates were reduced, we had a lesser liability, but the government has rules which say how quickly we can give that amount back that it represents that liability reduction.
Yes.
On certain differences related to that deferred tax liability.
Okay. So again, you probably have already answered this, but which of the two, I guess I'm focusing on the 2 amortization periods that happen in the settlement agreement of 2 years versus 32 years. Which of those periods was controlled by the federal standard?
So maybe this is another way to say it. The reason we have a long period for some of it is because the federal rules apply.
Okay. Thank you. That's helpful for my rudimentary understanding of the distinction between the two. And I saw that in the settlement itself, I saw that the 7.12 million was inclusive of $378,000 in carrying costs. But I couldn't tell whether the other figure was inclusive of carrying costs or whether there are carrying costs in addition to that.
I can speak to the substance of that, but not necessarily the detail. The amounts prior to the rate change or the reduction in the tax rate were included in rate base. So the fact that there was a rate change did not change the amount includable in rate base. So customers continued to get the full credit as if the 35% rate were in effect.
Okay. And that amount that for the 712 million inclusive of $378,000 in carrying costs. Was that the weighted average? Was that arrived at through the weighted average cost of capital?
I'm not sure, that predates me.
Okay.
And just to clarify, I think you meant 7.1 million.
I did. 7.120 million is the number. Yep. And page 5 of the testimony discusses how CNG's rate application in this proceeding isn't seeking to make any adjustment to the 32-year amortization that's ongoing. But that on page 5, it references an adjustment for IRS normalization rules. Just for clarification again, to follow along, is that adjustment the same adjustment that's later discussed on page 7 of the testimony?
Well, I think we should clarify on lines 11 through 15. I believe we say the company recognizes that as part of this case, it will need to adjust the amortization to maintain compliance with the IRS normalization rules.
Yes. Yes, understood. I was just trying to make sure I was tracking that reference to, hold on a second, I think I lost you. Which page on line 11 were you just?
I was on page 5 of 16 beginning line 10.
Okay. Oh, I see. I think, one moment. Okay. And is that the same adjustment that's described on page 7?
Which line on page 7 are you?
Just a moment. Yeah, right at I'm referencing the top of page 7. There's the question about the additional issues to raise concerning the normalization rule, and there's a description. There's a response to that question. I just wasn't sure if that response is the same adjustment that's referenced on page 5.
Yeah, so this is a specific change required to make sure we adhere to that we conform to known changes that are required based on what has been assumed in this case. The item on page 7 is more of a protective clause that we've included in other cases just to kind of ensure that should anything happen, and by anything, it's not a doomsday prediction. It's more of a, sometimes the IRS will issue subsequent clarifications that tell us that a company should have done something maybe slightly different. And when you learn these things, you want to be able to conform. And I think we say that we would, come to, Pure, to ensure that, nothing got approved without Pure's consent, but we want permission to maintain compliance is all. So there's nothing specific we have in mind with regard to the page 7 amount right now.
Okay. Thank you. And I'm almost done. Page 13 discusses the gas repair safe harbor and just mentions that, I'll find that. It's actually page 14. At line 10, says the company doesn't anticipate a material impact. Has the company calculated what the revenue impact of that safe harbor would be? I guess, sorry, let me retract that. My first question was, by material impact, is the company saying it doesn't anticipate there'd be a material impact on the revenue requirement?
That's correct.
Okay, so now I'll ask my second question, which is, has the company calculated what the revenue impact of that safe harbor would be?
No, but what I will say is the company has computed some very significant repairs deductions as we testified to in our testimony. We also have people involved in the calculations who are subject matter experts in this area. And so we've consulted with them to make sure, both on the preparation side and just available as tax phone a friends, if you will. And we reach out to people to make sure we are getting the right information to consider so that we're making sure the customers are properly advantaged if something comes up that they can benefit from. And when you consider the totality of the information we've received, we've concluded that there just would not be a significant impact on this, because the methodology we have, frankly, is just a good methodology.
Okay, so does that mean that there is no revenue requirement request associated with this proposal for this rate case?
With regard to the safe harbor?
Yes.
No.
Okay, so is the material impact meaning does the company not yet know the material impact until, if this proposal is allowed, the material impact, if there is an impact on revenues, would that not appear until a subsequent rate case, like in a future test, in a test year in the future?
If we were to ultimately conform to this methodology, you could see potentially smaller benefits. You could potentially see higher benefits, but my belief is that you would not see a substantively different benefit because of, again, the nature of our methodology. Just for background, we've been waiting for this guidance in the industry for I think close to 10 years, maybe a little more, maybe a little less. So companies have had to, on their own, develop what they thought were audit-proof processes to claim these deductions. And so, if you think about it that way, 10 years down the road, we finally get guidance. Well, if we weren't doing this in a good way, then we'd have 10 years of exposure. So everybody was incented to come up with a process that made sense. And the electric industry already had guidance, so the principles that the gas industry followed were not radically different.
Okay. Thank you. And my last question is, there's just a reference on page 16, line 5, to an ongoing DRS audit that was ongoing as of the time of the testimony. I'm just curious if there's any update, if that audit's still ongoing, and if not, if there's any update on the gross earnings tax.
Yes. We respond OCC-408, a supplement, and we state that the audit was closed and the results.
Okay. And do the results of that audit are they going to have an impact on the revenue requirement that's filed in LFE1?
No.
Okay. Thank you. That's OCC's last question.
Thank you. Attorney Luigi, Attorney Wright, Attorney White or Wyman, Commissioner Karen,
No, thank you.
Mr. Vice Chairman. I don't have any questions either. Attorney Venora, do you need a moment to consider redirect?
Just a moment, please. Thank you.
Attorney Venora?
Yes, thank you. We do not have any redirect.
Very good, thank you. Let's move into the same panel, but for SCG. Any different witnesses?
No, we have all the same witnesses for the SCG panel.
Okay, any additional materials to adopt?
No, I'll just ask them the several standard questions that we've been asking our panels. To each of the panel members, do you all recall answering a series of questions from Mr. Vaughn at the start of your testimony for CNG on the tax topic?
Yes.
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 Thank you. And do you also recall answering questions on cross-examination from Pura staff and the OCC during that portion of the hearing?
Yes.
And in appearing now for SCG and for purposes of administrative efficiency, do you adopt your testimony from the CNG transcript and stipulate that if asked those same questions again, your answers would be the same?
Yes.
Thank you. The panel is available for cross.
Thank you, Attorney Venora. We will begin with cross from the authority staff, Mr. Fath.
Good afternoon again.
Good afternoon.
Again, for the record, although I'm quite certain you probably remember me from a few minutes ago, I'm Ryan Path, a consultant to Pure and Pure staff. These questions will be somewhat familiar, but I would like to get confirmation that there's no subtle differences. The Connecticut Fixed Capital Investment Credit Program, it's the same program in SCG as it is in CNG, correct?
Yes.
And do you know how long this program's been available to SCG?
Same answer as I gave for CNG.
And the first rate case in which the impact of these credits would have been incorporated into the company's revenue requirement. Are you aware of that?
I'm not certain, but I believe it's been available for some time and they would have availed themselves of the credits to the extent they were able.
And in the previous case, these credits were calculated roughly as 5% of the company's annual fixed capital investments. Is that correct? And I should probably clarify my question. When I say annual fixed capital investments, I mean the annual fixed capital investments assumed in the rate year.
I would assume that it would have been based on some sort of qualifying percentage and this applies to CNG as well. But I would have not every capital expenditure would qualify for the credit. So, for example, vehicles would not qualify, structures would not certain structures would not qualify. So but just the simple concept is we multiply qualifying expenditures by the associated credit rate. Perhaps for administrative efficiency, I can say now that the answers for SCG are going to be essentially the same as those for CNG, if that would help.
Okay, and just so I'm clear about the time period that you use for this calculation, that's the rate year, correct? And when I say that the time period you use for that calculation, I mean what you're multiplying the 5% times that investment number is driven from the investments that you anticipate in the rate year.
That's what I believe.
Okay, thank you. And has there ever been an instance where the company utilized more FCIC in a given year than it assumed in its rate case filing?
If the company earned more credits than were assumed in rates, the reason for that would have been presumably that it invested more capital than it put into rates. So it's again possible it could be higher or lower.
Thank you. And do you know if the FCIC was included as a distinct line item in the revenue requirement calculations for the settlement agreement in the previous case?
Similar to CNG, I don't know if it was a separate line item, but I believe the credit benefit was included.
Well, can you please open up RRU 812?
I have it.
Okay. In this discovery response, the company quantified the pre-grossed up revenue requirement impact of the company's proposal for SCG as $145,772. Is that correct?
That is correct.
And the post grossed up amount is what would be in actually impacting rates. Is that correct?
Would you repeat the question?
The post grossed up revenue requirement amount is what would actually be embedded in rates. Is that correct?
Yes. I think, as we've perhaps covered all this with CNG, perhaps we could just take the same late file for SCG that we've already taken for CNG.
Okay, and Mr. Pfaff, so I had the two late files that you asked for, 57 and 58. We want those repeated.
Yes.
Okay, so those become late file exhibit 60 and 61.
And just to confirm, will the company be incorporating both the annual revenue requirement impact and I guess the total impact in its response? Which to clarify would be that the annual impact multiplied by the 40-year amortization period.
Just to make sure I'm following, you're looking for the impact each year and then the sum total of all of the years of impact.
Yes.
I understand.
Okay. And that would, as we discussed before, but just to make it clear on this record as well, that would include all the revenue requirement impacts from the amortization and from whatever revenue requirement impact was related to rate base.
Yes.
Those are all my questions. Thank you.
Thank you.
Good afternoon again. Sulaiman Bakir for Corporate Staff.
Mr. Bakari, I think your microphone might have been turned off.
I have it.
Could you explain if SCG normalize or flow through the IT effect of its RT deduction?
SCG normalizes its repairs tax deduction.
If you look at that response, could you explain why the RTD for 2022 is 3 times that of 2021?
Similar to what I said with regard to CNG, the process that we go through is a very, it's a sampling process that looks at whatever substantively work orders we randomly sample. And sometimes we will find that those samples produce a lot of repairs qualifying items, and sometimes they don't.
Okay. Just for clarification, the amount for 2022 and 2023, those are the amount that shows up on the company 1120 line 14, is that correct?
The amount that shows up on line 14 includes the repairs tax deductions, yes.
You testified earlier that SCG normalized. Are you aware of any Connecticut utilities that flow through the IT related to repair tax deduction?
I am, as I said before, tangentially aware of the possibility that some company might do that, but I have no specific knowledge based on observing it.
when did the SCG first started accruing the expired FCIC as reg asset?
I think the answer would be the same. Oh, excuse me. I think this question is best covered in the late file that we've already agreed to take.
Okay, I believe 561. Yeah.
Yes.
Okay. Would SCG be able to provide a worksheet that shows the calculation of income tax expenses for 2022 and the rate year under the assumption that the company reflect DIT effect of RTD using the flow-through methodology instead of the normalization approach?
I believe this is a similar request for what you asked for CNG, and the answer is yes.
Chairman, would that be late 562 or late 563?
We're up to 62. So you're asking for the companion to 59?
Yes.
Yes, we are up to 62.
Chairman, that's all my questions.
Thank you. Attorney Wheel.
Hello again. I'm still Tom Wheel from the Office of Consumer Counsel. Okay. I have similar but different questions for this panel than I asked from the CNG panel. My first question starts at the initial testimony on page 4. Just about the discussion about the Tax Cuts and Jobs Act of 2017. The testimony here discusses the reduction in corporate income tax rates from 35 to 21% and the resulting reduction in SCG's tax obligations after 2017. And it's going to get a line reference. On page 5, line 3, actually starting on line 2, it says the amount of ADIT recorded on the company's books became larger than the amount needed to pay its future tax liability. Can you just, I think that this is a similar explanation as what the panel explained for CNG, but can you just explain, since this is a different kind of description, in basic terms, what that means?
It means that, generally speaking, we collected taxes that we owed the government at a 35% rate. And then when the government changed the rules and said we had to pay it back at a 21% rate, we had, in essence, an over accrual, which allowed us to be able to provide back to customers that difference.
Okay. And what was the effective date of the reduction to corporate income taxes?
12/31/17.
So does that mean, is it your understanding that income received on or after that day was subject to the reduced tax rate? Or was it income received on or after January 1st, 2018?
The new rates took effect in 2018.
Okay. Do you know what date in 2018?
No, January 1st.
Okay, thank you. And a moment ago, I think you said that generally speaking, the company collected taxes to pay the government a 35% rate. Just to be clear, the company collected those taxes from ratepayers, correct?
For purposes of this hearing, we're confining my comments to the taxes due to the government as a result of its operating activities.
Thank you. I just meant for clarification. I think you used the word collected taxes, and we're talking about the company collected.
Yes,
revenue
from customers.
Okay, thank you. And your testimony on page 5 discusses the proposal for 2 regulatory liabilities. Are those kind of conceptually similar to the 2 liabilities created by CNG in its settlement agreement and described by the CNG panel earlier?
They are essentially, they're substantively the same types of liabilities.
Okay. Thank you. And the testimony here discusses a settlement agreement in 170542 and an order from PURA in docket number 180115 that instructed the company to establish regulatory liabilities. Is that a reference to the final decision in docket number 180115 issued on January 23rd, 2019?
Is your question the excerpt? Is that from that docket?
My question was actually just whether well, that's a good follow-up question. My question was whether just the reference to the final decision on line 10 of page 5 is to that final decision in that docket.
I think the answer is yes.
Okay, and that is that excerpt in the testimony quoted from that final decision?
Yes.
Okay, thank you. And that final decision instructed the company to accrue carrying costs at the weighted average cost of capital, is that correct?
Yes, that's correct.
And has the company been accruing carrying costs at the weighted average cost of capital?
Yes.
And when the company is computing those carrying costs, what did the company use as sort of the start date? Has the company been accruing those carrying costs since the date of that order, or since a prior date, an earlier date?
So I believe in OCC 256, we provided that information in attachment 1, and it confirms that we began accruing carrying charges as of 1/1/2018.
Thank you. And we've discussed this, I think, in other panels. I don't remember whether with respect to these particular regulatory assets, this question has been asked, but when the company says it's been accruing carrying costs at the weighted average cost of capital, does that mean simply that I guess is the mechanism for those carrying costs, the fact that this is being held as an offset to rate base?
Not in this case. As shown in the attachment Mr. Bieber just referenced, we separately computed carrying costs, and that calculation can be found on page 6 of that attachment.
Okay. Thank you. And why was there a separate treatment in this case?
It wasn't in rate base.
Okay. That's because the revenue, the original incoming revenue from ratepayers wasn't in rate base. Is that what you mean?
The liability that these carrying charges are based off of was not in rate base.
Okay. Why not?
The rate case predated tax reform. So it wasn't contemplated at the time that the rate case settlement was reached.
Okay.
And so we've received money from customers that we're holding on to that we need to refund. And so there's an inherent cost of capital for them. And so we put carrying charges on it and refund the carrying charges plus the amount that we've over collected.
Okay. Thank you. This is similar to some questions I asked of the last panel, but I think it's specific enough to this testimony that I'm just going to ask again, similar questions again. On line 20 of page 6 of the initial testimony, it says SCG will refund the protected component of its EADIT balance over the required period. So I have questions about the two of those terms, the protected component that's referenced in that line. Just to be clear, is that the 51.442 million number that's reflected in the table on page 7?
Yes.
Okay. And the reference to the required period on that line, what is the required period?
When you use the reverse South Georgia method, it's based off of the weighted average composite rate.
Okay, but in terms of years, what's the period that the company is proposing to refund that 51.442 million?
So in our application, we assumed a 45-year reversal period. We still, as we stated in testimony, have to go through the analysis we do to make sure we're staying in conformance with the IRS rules. And so that analysis may produce some required update as part of the normal LFE update. But we don't expect that will have either an impact or a significant impact when considered in totality with the unprotected amortizations.
Okay. Thank you. And conceptually, that 45-year reversal period or whatever the ultimate period is that derived using the same principles as the 32-year period was derived for CNG?
Yes.
Okay. Thank you. So then, well, similar to CNG, there's another component to the proposal, which I think you just referenced, which is there's a different amortization period being proposed as to another component of these balances, correct? Is there also a 10-year amortization period being proposed?
I think you're speaking with regard to the post-remeasurement piece, so the non-deferred tax piece.
Yes. So is that the figure also on page 7 of the testimony in the table of 47.401 million?
Yes.
Okay. And what is the company's amortization proposal for that amount?
As Mr. Hurwitz testified, the period over which the balance is being amortized is over 10 years, but the amount here, just to be clear, is the amount as of the end of the test year and not the amount subject to amortization as of the rate year.
Okay. And is that amount that will be subject to amortization as of the rate year, is that also still being finalized for late file 1?
No, it is not.
Okay, and what's that final figure?
As reflected on schedule SCG WPC 3.23, line 7, that final figure is approximately 67.964 million.
Okay, thank you. And is that inclusive of the weighted average cost of capital carrying charges spread across the proposed 10-year amortization period?
This reflects historically recorded carrying costs. One moment. And part of our proposed revenue requirement is then to reflect this balance in rate base, which will address the carrying cost going forward side of things.
Okay. Thank you. And similar question to the question I asked with respect to the protected balances. Is that similarly conceptually to the amount that was amortized over 2 years in the CNG settlement?
The slightly less than $68 million amount that Mr. Hurwitz referred to is the post-remeasurement piece for SCG that is comparable to the approximately $7.1 million CNG amount that represents a post-remeasurement liability as well.
Okay. So acknowledging that there's a very large difference between the two numbers, one being 7 million and the other being 68 million, the 7 million is the analog conceptually to the 68 million. Is that correct?
That's correct.
Okay, thank you. I just have my last two questions are similar to what I asked for CNG, so I'll ask them I'll just ask whether the responses, would there be any difference in the response? So page 15 of this testimony discusses the optional gas repairs safe harbor. And page 16 mentions that adopting the safe harbor is not expected to have a material impact. I asked that question of CNG. I asked a question about whether the material impact references an impact to the revenue requirement and also whether it's been calculated. Would the responses here be the same?
Yes.
Okay. And I also asked a question about the reference on page 18 to an, at the time of the testimony being filed, an ongoing DRS audit. I asked whether that audit had been completed and whether there is any resulting impact on the revenue requirement. Would the response there be the same for SCG?
Yes, same response.
Thank you. That's all OCC's questions.
Thank you. Attorney Inoue, Attorney Wright. Attorney Wyman, sorry. No, either way, okay. Great, Commissioner Karen?
Sadly, no.
No questions, thank you. Attorney Venora, and a moment to consider redirect.
Yes, just a moment.
Wait. That's bad. Your office over here.
The company has no redirect.
Thank you, then this panel is excused. Let's go ahead and bring up the gas operations panel so we can at least get the administrative matters out of the way. And actually, Attorney Venora, while they're doing that, and I'd invite the OCC to approach. All right, while they're getting settled, I just have a administrative matter here. The gas operations panels, even if the cross estimates are correct, a total 3 hours. And we've been running a little ahead when it gets to the SCG. And effort not, I can't start capital investments tomorrow and I can't start cost of capital tomorrow. And then earlier I was flipping through. I don't think I can start clean energy innovations because I don't think Conservation Law Foundation's witness is available. So that brings me all the way to page 32, compensation and benefits. And I guess I'm looking for thoughts on whether we try to do compensation and benefits panels tomorrow and if that bleeds into the start of Monday, but I just don't want to lose all day tomorrow because I don't think we're gonna have gas operations that long.
Yeah, the only concern we have with that is the comp and benefits panel. We told them to be prepared for next week based on the estimates. I'm not sure they'd be prepared for tomorrow. Would there be an option of starting capital And then since they were shown, and then we could pause depending on where we are. And then take up the cost of capital till that finishes and then resume on the capital panel.
Yeah, I'd rather not start a topic and interrupt it. Are any of the companies later panels available?
Yeah,
Like there's
could
that
we-
environmental remediation, that's short. Oh,
Yeah,
I'm sorry.
I'm sorry, I'm talking over you.
No, I'm sorry. I have somebody else approach. No, nope, just, okay. Okay. I'm trying to see if anyone else wants to be heard on this. Okay. All right, sorry, go ahead, Attorney Venora.
Sure, we can check. I just want to, just to make sure, we'll check and report back before the close today on the potential availability of comp and benefits, or I know environmental, I think, is more of a challenge because they're those witnesses are farther away.
Yeah,
So let us check while this crosses happen, or this panel starts up, and then we can report right before we close today.
okay, because I think if that panel's not an option, just like flipping through the rest of them, then I think we're going to be in the place of doing this panel and the SCG panel and then calling it a day tomorrow, which I imagine some people aren't opposed to, but I
Yeah.
just want to go through all options. So
Okay.
for now, let's start with administrative matters. And if you want to introduce, I guess, your primary witnesses, and I'll swear them in. Oh, I'm sorry, you can stay. You can, let me be more polite. Please stay. We may start cross here. Let me see where we're going here. Go ahead.
Mr. Langland, you were previously sworn, but I would ask the panel to introduce themselves and state their full names and positions for the record.
Albert Langland, Vice President of Gas Engineering and Operations for Avangrid.
Giancarlo Romero, Senior Director of Gas Operations.
Richard Dion, Director of Planning, Scheduling, Resource Management.
Okay, thank you. Then we have our two new witnesses. I will administer the oath. If you could raise your right hand, please. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you. Attorney Vaughn?
Mr. Dion and Mr. Romero, as part of your preparation for this docket, did you provide pre-filed direct and rebuttal testimony and exhibits, which were marked as exhibits CNG, GOP 1 through 3, SCG, GOP 1 through 3, and exhibit CNG/SCG, GOP rebuttal 1?
Yes, I did.
And Mr. Romero, did you also co-sponsor pre-filed direct and rebuttal testimony as part of the Clean Energy Innovations Panel, which were marked as exhibits CNG-CEIP 1 through 9, exhibits SCG-CEIP 1 through 9, and exhibits CNG-SCG-CEIP rebuttal 1?
I did.
And to Mr. Romero and Mr. Dion, did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes,
I did.
And do either of you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in an interrogatory response?
No.
Do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
I do.
And to the panel, including Mr. Langland, for purposes of admission into the record, have you reviewed and do you adopt the interrogatory responses submitted by the other witnesses identified in the revised hearing agenda for the gas operations panel?
I do.
Yes,
I do.
Thank you. The panel is available for cross-examination.
Thank you. So let's go about 20 minutes. So Attorney Wheel, if you want to get started here, please.
Sure, thank you. Tom Wheel from the Office of Consumer Counsel. I'll start with page 11 of the initial testimony. I have this habit of directing you to page numbers and not being on them myself, but
I'm there.
thank you. So I'm just looking towards the bottom, the discussion of leadership changes. The testimony just discusses the hiring of you, Mr. Langland, in July of 2020. And I noticed, Mr. Langland, your position as discussed on page 1, just the background portion of your testimony is Vice President of Gas and Hydro Engineering and Operations. I guess just as an initial question, does that position encompass more than just the leadership of the gas operations?
It does.
Okay. And is that just based on the title alone? Is hydro engineering and operations a separate?
We have 9 hydroelectric plants in upstate New York that I have responsibilities for.
Okay. And the position, I guess the component of your position that's the leadership for the gas operations business of CNG, was that a new position in 2020, or were you replacing somebody else who had?
I was replacing an individual who had retired.
Okay, thank you. Pages 11 through 12 of the testimony generally talk about the leadership structure of the gas operations department, and that there's been a reorganization of key functional areas and an establishment of two, I think, new functional areas. Was that reorganization envisioned in the company's prior last rate settlement that's been discussed in prior?
It was not.
Okay, so that reorganization happened since that time, since the last rate case?
Correct.
Okay. So is this rate case the first time that PURA has reviewed that reorganization?
That would be correct.
Thank you. Page 14 of the testimony notes that the planning and scheduling organization is relatively new. And I looked at exhibit CNG GOP2, which is the organizational chart. And I see it looks like there are 4 employees or full-time equivalents listed as part of the planning and scheduling organization. Is that correct?
Let me get there. What were you referencing again? I'm sorry.
Planning and scheduling.
In the org chart exhibit?
Yep, I'm looking at the org chart exhibit. I'm just looking at the far right portion of that exhibit, which it looks like there's an open position, which appears to be the head of the planning, scheduling, and resource managing department. Is that?
That's right. That position is now filled with my colleague, Mr. Dion.
Okay. And then there are 3 employees on the organizational chart that appear to report up to that position, to Mr. Dion. So is that the entirety of that department?
It's not.
Okay.
There are other individuals that are reporting to those folks in the blue boxes.
Okay. So is this organizational chart sort of just a management level view of the organization?
It is.
Okay. And are any of those positions in that section of the org chart, I guess do you call it the planning, scheduling, and resource management department?
We do.
Okay. Are any of those positions new since the company's last rate case?
They all are.
Okay. What other positions shown on this organizational chart are new since the last rate case?
Just get back there for a second. Yeah, just a correction on that. The planning and scheduling group is new, but there are positions underneath that director that existed prior to the reorg.
Okay, just going back to that for a second. The 3 positions reflected on this chart, are any of those new, or were those kind of moved from a different department?
Yeah, so the dispatch position was there, and Rick, why don't you take this one because this is your area.
And the manager of meters was there as well.
Okay, so that's Mr. Bowen. Is that holds that position now. So would it just be the workforce planning and scheduling as well as your position that were new since the reorganization?
That is correct.
Okay. And how about any of the positions that report up to these three individuals and yourself? Are there new FTEs since the last rate case in that department?
Yeah, the manager of resource planning, that's an entirely new department.
Okay. Just another question about the chart itself. I see some grayed out positions. And I'm assuming based solely on the position all the way at the top to the far left is labeled as New York operations. My guess is that the reason these are grayed out is that these aren't part of CNG's Connecticut operations that are subject to this particular rate proceeding.
That's correct. They're not part of CNG or SCG.
Okay. Thank you. And these, that was actually going to be my next question is, are these, I noticed that there's what appears to be an identical organization chart filed with the SCG testimony. Are there any differences between those two charts?
No.
Okay. I just noticed that a lot of it seems like the reorg happened primarily in 2021. Is that accurate?
It is.
Okay. And I noticed on page 11 of the testimony on line 21 that talks about plans were underway in 2021 to reconfigure. And it also talks about on page 14 talks about the gas compliance and operational performance group being formed in 2021. I was just trying to get a sense of the general timing. Like, was there a singular decision in 2021 that sort of set forth the reorg altogether?
I was hired in July of 2020. I want to say I assessed the organization over the first 6 months and realized we had some areas that we needed to put some additional focus on.
Okay. Thank you. And I also noticed, I think, Mr. Romero, in the section of the testimony that just talks about your background, I think I noted that you joined Avangrid in 2021. Is that correct?
That is correct.
Okay. So was that also part of this reorganization? Your hiring at the company?
It was not.
Okay. And Mr. Romero, your position, was that a new position since the company's last rate case, or were you also a successor to a position that already existed?
That was an existing position.
Okay, thank you. The reason I'm curious about 2021 is just for confirmation, and it's not sure whether this panel I'm sure the panel knows, the 2021 was the last rate year for CNG coming out of the last rate case. Is that correct? I see Mr. Hurwitz approaching.
That's correct.
Thank you. So I guess I don't want to assume, but based on your testimony, Mr. Langland, that you joined the company in 2020 and that settlement predated 2020, and it sounds like this reorganization was your plan. Was any of this reorganization, any element of the reorganization contemplated in the last rate case?
No, it was not. I think the fact that I didn't know that it ended in 21 kind of shows that.
Thank you. It's also kind of rate making nerd stuff, so don't feel bad that you do it. No offense to Mr. Hurwitz. Do you know what the total requested revenue and the revenue requirement in this plan is associated with any of the new positions that were created as a result of this reorganization?
We have not specifically quantified that. However, we have submitted some data requests quantifying the effect on the revenue requirement of one FTE.
Thank you. So would it be accurate then to, if we counted up the number of FTEs that were incremental as a result of this reorganization and multiplied it by that, that would be an accurate reflection on the revenue requirement resulting from the reorganization?
The result of the reorg, we moved positions around, but there wasn't anything incremental.
Okay. By incremental, I meant incremental to the FTEs currently recovered in rates as of the 2021 rate year. And so were there no new FTE, I guess for rate making purposes, no incremental FTEs associated with the reorg? Is that what you mean?
Correct.
Okay. So although new positions were created as a result of the reorg, those were positions that were just moved from other slots and weren't duplicative.
That's right.
Okay, thank you. So I guess, not to be overly blunt about it, but the answer to my last question then would be there is no revenue impact associated specifically with FTEs associated with the reorganization.
That's correct.
Okay, thank you. On page 15 of the initial testimony, which I will also go to now. On line 16, it says the company is observing favorable results in many of its key performance indicators, its work plan execution, its backlog mitigation, its fulfillment of compliance obligations, and its responsiveness to customers. I was just curious about the characterization of favorable results, whether that's like a comparative characterization, meaning was the company kind of tracking those metrics historically and saw an improvement in those metrics?
That's right.
Okay.
These are the same metrics that we've been tracking historically. If we look at, 2023 represented the best years for the CNG, SCG companies with respect to emergency response, leak backlog, excavation damages in particular.
Okay. And the key performance indicators referenced here, are those metrics you just referenced included in those?
That's right.
Okay. And have you filed a historical look back showing the improvement of those key performance indicators?
I believe we file these on a quarterly basis. We file these with Pure on a monthly basis.
Okay. Do you know whether they're in the record in this proceeding?
Some of these documents are. For example, on emergency response, we show our progress on page 16 of the testimony. Damage prevention rates are covered on page 17 and 18. Similarly.
Okay. Would it be, and this might be a question for Attorney Venora, would it be, either way works for us, but we'd like to be able to reference those reports, and we can either ask that they be added to the record as a late file exhibit, or if the company wants to stipulate that since they're filed with Pura, we could just reference them as in the public record.
Mr. Attorney Wheel, can you I was focused on the schedule for a minute. Which report specifically?
Sure. We just had some testimony. I asked some questions about the improvements in key performance indicators, and the testimony responded that there's monthly filings with PURA that include those key performance indicators.
Right.
So I was just asking, I'd like to be able to see all of those dating back to 2021, as Mr. Romero indicated. Some of that is in this record, but some of it isn't. But all of it would be in those monthly filings. So I can either ask for the company to file a late file of all of those monthly filings as an exhibit in this case, or I asked whether the company would stipulate to us just being able to reference them since they're filed in PURA dockets.
I think I'd prefer that they were specifically in the record. I think that's clearer in this case. So, I think we can take that back and work to provide that.
Okay, so that's late file exhibit 63, and which is probably also a good place to stop, but provide copies of the monthly filings dating back to 2021. Do you have a docket number, or do you just want me to generally? You just file them on docket?
Yeah, it's multiple dockets, so.
Okay, so just
they
say
filed them or something.
monthly filings dating back to 2021 regarding key performance indicators.
Yes, and maybe more specifically regarding the metrics referenced on page 15 of the testimony.
Of the
In
gas operations testimony.
Yes.
Okay, thank you. So we'll stop there and pick up with the OCC's cross of this panel tomorrow. Attorney Venora, thoughts on my schedule question?
Yeah, so we were trying to figure out if we have any good options for either the comp and benefits panel or the environmental panel. And unfortunately, neither of those will work because those witnesses are on call for next week sometime. And they're also in a couple cases like in Rochester, New York. So it takes a little time. So what I did do is I counted. So if the estimates hold for the gas operations panel, I figure we would finish that probably before lunchtime tomorrow. But then when I look at the estimates for the capital panel, we could potentially start the capital panel and then finish on Monday. My estimates for cross on the capital panel are going to be substantially less. I think we reserved 3 hours in one instance. I think that will be substantially less. And if it goes like we expect, the subsequent reservation of time during the SCG portion, I think will be also be much less than it is. So, so that would be one option, to start capital tomorrow, potentially finish capital on Monday, and then we can do ROE on Tuesday, the 30th, when Dr. Woolridge is available and Ms. Bulkley is also available.
That would work for us, with the one caveat that I think I did raise administrative matters to begin with. Our capital investment panel witnesses can't be here tomorrow, but I think tracking Attorney Venora, I don't think we would get to them until Monday. But they actually, I initially instructed them to be here first thing Monday morning, and that still is possible. So, and they can be here Tuesday as well, so that would work.
Okay, I think that's a good path forward. So we'll pick up with gas operations and then plan to move into the CNG panel. We will stop after we complete the CNG capital investments panel, assuming that we get that far tomorrow.
Yeah.
Okay.
Okay.
All right, very good. Thank you, everyone. And we will see everyone back here at 10 a.m. tomorrow.
Okay, thank you.